We are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel this morning are Justices Jeffrey Kinder and John Englander. We will be the panel for all 6 cases on the hearing list for argument today. First case on our list for hearing is case number 2020 P537, HAVERHILL STEM, LLC and another versus LLOYD A Jennings and another. You may begin.
Thank you, Your Honors. My name is Alvin Nathanson, and I have with me Attorney Scott Schlager from our firm, and we represent the defendants in this appeal, which is essentially an appeal under the doctrine of the present execution. In particular, I want to address my remarks today to the 2, what I believe to be the major issues in this case, the anti-SLAPP matter and also the absolute litigation privilege matter. Now, insofar as the anti-SLAPP matter, this is a rather serious and very important case. And you'll see in a few moments as to why I believe Judge Deakin committed error in not dismissing this particular case. The facts are a little bit muddied up, but I think if you look at the overall record and in particular, not rely just as Judge Deakin did solely on the complaint, but in this particular case, the court allowed the parties to take depositions, and we did depose the defendant and her attorney, and I would believe personally that that testimony would be much more reliable than just looking at the complaint in particular, since it was cross-examination. But in any event,
Mr. Nathanson, can I interrupt with a question, please?
Sure.
The complaint alleges, and the record seems clear, that your clients felt that the building owed them $30,000, and it seemed like that fact drove the negotiations, at least in part. It was difficult for me to grasp how that fact, that is the claim for $30,000, related at all to the opposition to the marijuana dispensary.
Well, first of all, the case law holds that the motivation for what our clients did is irrelevant. That was a ruse, and unfortunately, the judge did not look at the total overall context. That $30,000 was a claim for a deck that had nothing to do with the plaintiff. It was with a prior owner. It was a prior dispute. And in particular, if you look at the overall record, that was just an amount that was used during settlement negotiations as a starting point, because it obviously went up. And if you look at what the parties did here, Judge, you will see that they negotiated over a long period of time. And what does most of the complaint say, and what does most of the testimony was about the marijuana facility. Had nothing to do with the $30,000. That is not only irrelevant, but that was not the basis for the negotiation and not the basis for the judge, who, by the way, found it was core petitioning activities.
Well, if I might interrupt, the complaint alleges that in a particular meeting on April 8th of 2019, what you call settlement negotiations, Mr. Nathanson, one of your clients said, the Pignots don't have the money to fight him, and he has already won, and he was prepared to take everything from the Pignots, including their house. In any of the depositions, did your clients deny that they had made that statement?
Yes, I believe in affidavits they denied. They denied it. I wasn't present at the deposition. My associate was of the client, but I believe they did.
Did Pignot did anyone ask her whether she was recanting that was a statement that was made?
I don't believe I asked her that particular question. I did ask her about the threats, what she meant by that. And that's in the record, and that's in
Yeah, but if you don't, she alleges this, and you don't establish that it did not happen, isn't that a fact that we have to address in the context of determining whether or not these statements are actionable?
And I believe they are not, as indicated in my brief. They are not true threats, Your Honor. The case law is very, very clear as to what is constitutionally protected and what is not. And number one.
Well, no, they don't have to be true threats. All they have to be is the basis for a legitimate claim that isn't a claim that is motivated solely by your client's petitioning activity.
Well,
Or
okay.
have I misrepresented what the anti-SLAPP law is? That's my understanding of it. If they have, in order for you to succeed, you need to show that her claim was motivated solely by your petitioning activity. If they have a legitimate claim that is separate from that, and it doesn't have to be true threats, does it? All it has to do is satisfy 93A or satisfy potentially the Massachusetts Civil Rights Act.
That's not my understanding.
Okay, explain to me why I'm wrong, because you're going to have to work at it, I'm afraid.
Well, first of all, petitioning activities are defined in the statute as any statement made before either litigation or before a quasi-judicial litigation. It does not say any statement except as set forth by Judge Deacon. That's number one.
How is a statement that he's prepared to take everything from the Pinots, including their house, petitioning activity?
No, it's part of petition. It pertains.
How is it part of petitioning activity?
Because it was part of settlement negotiations.
There was no litigation. What this was a demand imposed before there was any active litigation or any effort to pursue or oppose a permit.
No, what the facts are as follows, Judge. The $30,000 again was with a prior owner. The only time it ever came up was after she approached our clients to get them to assent to her petition for a special permit. And that's when the discussion started. You see, the case law, and by the way, look at the case of Plant versus Wiley, 63 Mass App 151. Any statement made in connection with an issue under consideration for review. These were settlement.
I'm going to kill you.
Well,
Any statement? Come on, that can't be it, right?
no. Well, that's a true threat, Your Honor. You see,
Okay. So somehow we're imposing the First Amendment law into what otherwise a standard that doesn't really say that it's all First Amendment, though, does it?
But I'm sorry, I don't understand that. But
I mean, you're taking the true threat is a First Amendment concept, and you're saying that that's somehow being imported into our determination under the anti-SLAPP statute of whether they have a legitimate claim.
correct. Whether it's actionable. That's the.
Can you give me the rest of Plant against Wiley, 63 Mac what?
63 Mass 151. It's a 2005 case. And it was exactly that. It was settlement discussions.
No, but Mr. Nathanson, I guess the difficulty I'm having is that it seems to me that both in theory and in the context of the circumstances that led to this controversy, what you are suggesting is that someone can inoculate themselves from extortionate threats made to collect an antecedent debt so long as they somehow tie that threat to subsequently filed litigation.
First of all, there was no claim of extortion here, Judge.
Well, let's set aside for a moment the question whether this was itself extortionate. It's easy enough to imagine circumstances where that would be the case. But in any event, what you're suggesting is that an improper attempt to collect a non-existent but antecedent debt could be inoculated from action from recovery by somehow tying that into a subsequently prosecuted litigation.
First of all, Your Honor has to look at the complaint. You see that even the plaintiff used the word negotiations. And the judge even used it a couple of times in his decision.
The mere fact that they're negotiations doesn't mean that they are settlement negotiations, Mr. Nathanson.
Well, that's what they were. You look at her.
He also uses the word extort.
Look at her.
By the way, Chapter 93A, there are cases about whether commercial activity that approaches extortion is a 93A violation.
Again, they never claimed extortion. As a matter of fact, the judge threw out their harassment from them. But what we have here is you have settlement negotiations. And during the settlement negotiations, statements were made. They were not extortionate. They weren't even coercive. As a matter of fact, I got to tell you, I've been in the practice of law for many years, and I've heard a lot worse at settlement negotiations. So are we now going to draw a line that says if you cross this imaginary line, that somehow or other the anti-SLAPP goes away, the protection for petitioning activities where they were?
It seems to me there are two questions. You're raising two questions. One is whether you can ultimately be held liable for the statements that you made, and the second is whether you're entitled to immunity by virtue of the anti-SLAPP statute. And it seems to me that the only question we have here is the immunity question, the question of whether you can ultimately be held liable. That's a question for the jury when this case goes to trial.
Well, it comes into the second issue, Judge, the absolute litigation privilege. This was made in anticipation of litigation, and the word absolute means absolute.
The only litigation that it anticipated was litigation arising from the attempt to collect a non-existent debt.
No.
One of you at a time, please.
The judge found that there was an existing special permit hearing. That's a quasi-judicial hearing that they were proceeding to argue.
But surely during that proceeding, there would be no risk that Mr. Jennings would take her house.
Well, there could be, because first of all, I don't know what that means. I don't know what that means, Judge. First, does it mean we're going to spend a lot of money on litigation and ultimately, you see, that's the problem, Judge. You've got to understand that these, even if they were made, and most of them were denied, even if they were made, it doesn't affect the absolute litigation privilege because it was made during or in anticipation of either a quasi-judicial or a...
No, it can't be that the absolute litigation privilege, again, has as blanket an immunity, which is essentially what you're suggesting. It has to be, the statements have to be in some way related to litigation. And if the only litigation that's contemplated is an objection to her being able to get a special permit, I don't understand how these statements could at all relate to that. They're going to take her house. Can I ask you, is the absolute litigation privilege issue properly preserved? Because your opponent says that absolute litigation was raised in a motion for reconsideration. We have an order that denies it, and that you didn't appeal from that order. Is he right?
Well, Judge, if you look at his original decision, you will see at the end, he talks about a privilege prior to litigation. And that is the absolute litigation privilege in his initial decision that he was referencing. And perhaps, and maybe we were at fault for not explaining it further or in depth, but we
or
did
in not appealing from the second order.
Well, that was, I believe, part of the first order, and he did reconsider, and it's part of the record here. And
do you have any cases that help us on the absolute litigation privilege to understand where the line is drawn when the statement doesn't relate directly to litigation, but precedes it?
Yes, it's in my brief. And in particular, Judge, look at what they're relying on, the Gillette case. It's Gillette versus Provost. It's 91 Mass App 133, and it was a 2017 decision out of this court. And in that particular case, they held it didn't apply because they were written statements and also a baseless counterclaim. But they held that oral statements, all oral statements, are covered by the absolute litigation privilege. And
Right, but what were the facts of that case? Were the statements made in advance of anticipated litigation, and in what way?
the written statements, there were letters that were passed back and forth between the parties. We don't have that here. We have only oral statements. And secondly, they found that the counterclaim for abuse of process was also accepted from the absolute litigation part. They said it was a baseless counterclaim. And if your Shave's counterclaims arise out of conduct, not speech. Those are the exact words of the appeals court.
All right, I see that your time has expired, Mr. Nathanson. You can rest on your brief for the remainder. Thank you.
Thank you, Your Honor.
Attorney McMillan.
Morning, Your Honors. May it please the court. Needless to state, the plaintiffs believe that the judge's decision that was rendered on the motion to dismiss, as well as a special motion to dismiss, was complete and whole. It was methodical. It analyzed all the factors, both legal and factual, and the trial judge did not commit any abuse, and certainly no error of law. With that said, I think I'm going to jump to the absolute privilege that the defendant seems to be relying on here heavily at this particular point in time. If you look at the judge's order, which is attached to my addendum, and it begins at page 64, but at page 88, Judge Deakin says, finally, the defendants claim that their alleged statements are protected by privilege because they were preliminary to municipal hearings or pertinent thereto and are privileged. Defendant's special motion to dismiss at page 20 is without supporting legal authority or factual analysis. The defendants do not identify the privilege they purport to assert. The court therefore discerns no basis to dismiss count 6 on that basis. So the defendants failed to articulate their argument both at the time that they filed the motion to dismiss and the special motion to dismiss, as well as the hearing. So the judge.
What do you think this is properly before us? What do you say to the argument that there was an absolute privilege adverted to in their prior briefs?
No, they only bring it up. It got bootstrapped, and I think what happened is they were seeking to bootstrap the appeal of the denial of the motion to dismiss along with the special motion, because without asserting that it was a special, I do not recall the doctrine that the attorney Nathanson referred to earlier.
Present execution.
Right, doctrine of present execution. When they originally filed their notice of appeal back on April 16th of 2020, they did not include the motion to dismiss. It was just a special motion to dismiss. They then turned around and they filed an amended notice on April 14th of 2020. And this amended notice now for the first time tries to, as I indicated earlier, bootstrap the motion to dismiss so that it could have a hearing at this point, as opposed to having to live with the decision of the judge. And we could obviously go back to court and vet things out on the underlying complaint, because they don't have an interlocutory appeal with respect to a motion to dismiss, only the special motion to dismiss.
We're going to have to look at
They're both here. I mean, isn't there an interesting judicial economy when they've got dismissal on one basis that is properly before us to hear the any questions of legal propriety attaching to the related motion to dismiss?
Well,
I thought your argument was that the claim of litigation privilege was waived because it wasn't properly raised below.
It is, and it wasn't preserved because of the fact that they filed a special motion to dismiss. The judgment on that came, I believe, it was May 22nd of 2020. And I'm sorry, they filed it on May 22nd of 2020. The judgment came on June 3rd of 2020. They never amended their notice of appeal to then include the denial of the motion for
reconsideration.
Consideration. And
they
your
didn't allow
contention, I just want to pause for a moment because the judge wasn't required to undertake an independent analysis of a claim that was raised for the first time on reconsideration, but the judge did do so. Ordinarily, that would resuscitate that as a claim that could be prosecuted on appeal, but they did not appeal from that order. That's your argument.
And that is accurate. In fact, Judge Deakin, in both instances, both on the original order, he went to the next step after looking at the first stage of whether the special motion for dismiss should be granted to the defendants, and he addressed all the second phase with respect to the requirements under blank.
Counsel, can I interrupt for a sec? Because I think what I'd like to get at a little bit is this issue that your brother raises. He says, look, a lot of stuff gets said in settlement contexts. And are those statements actionable? Are they to be actionable in the way that you choose to say that they are actionable? And would you agree with me that there are a number of statements that you talk about in your complaint that are not actionable? For example, I'm going to fight you to the end. That's not actionable, is it?
So do you want me to address the issue of whether those were actually settlement negotiations and statement made in connection with settlement?
The question whether they give rise to a colorable claim.
I do believe that they do give rise to a colorable claim, taken in the totality of the circumstances, which is what the judge did in this case. He went back and he analyzed everything that was said, and then he applied it to each one.
Your client approaches them, they're the next door neighbors. She said, hey, will you agree that we can put in a marijuana establishment? They say, no, we're going to fight you to the end. That's actionable?
Well,
under what theory of law could that possibly be actionable?
That's not what they were fighting them on. Again, the defendants seek to direct the narrative to being settlement discussions with respect to the demands that they were making for $30,000.
Why aren't they settlement discussions, counsel? Your client is interested in having something happen. They are abutters. They have a right to object if they have a legitimate grounds for objection. And it's very apparent from the discussion and even from the allegations that they have some concerns that are legitimate related to the use that's going to be put to their neighboring property. Why can't they in that context say that has a value? If you pay me X, then I won't object. Oh, if you pay me X and you don't use the third and fourth floors in a particular way, then I won't object. Why isn't that all very legitimate discussions and in fact settlement negotiations?
Because it's not, there's no dispute to settle. We go back to the fact, and the judge noted, in contrary to
your client's approach to them
judge,
indicates there's a dispute to settle, doesn't it?
I'm sorry,
Your client, I think it's undisputed. Your client approached them. Doesn't that indicate there's something to be settled?
The settlement deals with the $30,000 that Mr. Brooks, who was one of the defendants in this case, indicated even before the issue with respect to the use of that building. It didn't matter what
they're interrelated. They're interrelated. These guys put an original price on it.
I beg to differ, Your Honor. They're not interrelated. It stems back to the 2017 construction of the deck that the defendants had to do, and they said it doesn't matter who purchases the building or what use is intended, they're going to get that $30,000. So
that may be true. That may be true if they had imposed the demand independently of the request for cooperation on the special permit process. But it seems to me that the source of the desire to obtain a payment is sort of beside the point. because at some point, once they are in a position where they are being asked to give something of value to their neighbor by their neighbor, they could have come up with that number from any source, right? It doesn't. The deck is immaterial. They could have had no reason at all. They just want to get money for their pockets, right?
Not initially, Your Honor. They wanted to get compensated for the $30,000 that they paid.
Well, they may have wanted that before, and all of a sudden now they have the opportunity to do that because of the permit application.
Well, the difficulty that we run in with that's not looked at in a vacuum. They constantly are increasing the pressure, not only the financial pressure from 30,000 at the initial request all the way up to 75,000 at the end of the last meeting, which occurred sometime in April of 2019.
Mr. McMillan, can we agree at least that the context in which these negotiations or discussions first arose was when your client approached Mr. Nathanson's client for the purpose of getting approval with respect to her intent to start a marijuana dispensary?
No,
Isn't that how it all began?
I don't think so, Your Honor. It's a little bit more generic than that. What happened, she didn't approach the next door property owners on either side to support what she was seeking to do with respect to that building. She actually went to the downtown community because the zoning had to be amended at that particular point in time to allow the operation of a licensed marijuana dispensary. So it's not like she sought out these two individuals. They just happened to be in a place where the plaintiff was requesting other individuals in the downtown community to sign her petition to have the city change zoning. So it's a little bit more generic than she sat down and started to negotiate with them. Once she
however it started, it had to do with the marijuana dispensary approval, correct?
No, it had to do with the threats that the defendants made that no matter who bought the building or what purpose it was going to be used for, they were demanding that they be reimbursed the $30,000, and that's why it's so distinctive.
At what point did they communicate that demand to your client?
I think it was
after she approached them about the marijuana dispensary issues.
But it didn't come directly. No, it was after she put in Caroline Pino put in a telephone call to Mr. Brooks, one of the defendants, who ironically happens to not only be her neighbor but had built her house, and she simply let him know at that particular point that she was moving forward to try and get the zoning bylaw changed. So yes.
But I guess the point is that there was no communication to your client of a demand for payment of $30,000 that was ever communicated independently of the request for a marijuana dispensary license.
Well, I know the court wants me to draw a nexus between the two, but we don't even have to. It's in your complaint. You draw the nexus yourself. It's in paragraph 16. I think you need to move on. You literally, your allegation, your complaint literally draws the connection. There are two phrases put together. They draw the connection.
So I guess at this particular juncture, then I would turn and ask the court to keep in mind the case of Rybach versus Haydock, which is 92 Mass App Court 567. And it was a case that was cited in my brief. And I also believe that the defendant cited it in their brief as well. And basically what it comes down to is in that particular case, the appeals court upheld the denial of a special motion to dismiss, because although one could infer that the defendant's persistent petitioning activities played a role in the plaintiff's decision to file the complaint, there was also an independent basis for the complaint that the defendants were intentionally interfering with the plaintiff's right and use to enjoy her property. And that obviously goes right to the heart of the MCRA claim. And the judge, in making his finding, also listed a number of other threats that were made. Not only that they take away her business, they interfere with her business, she doesn't know who she's dealing with, that the defendants are going to take away the house. There's also the threat with respect to the defendant Jennings' claim that he was going to burn down the deck. Now, I know that the trial judge did not give that a lot of weight, maintain that it was not necessarily well pled, but unfortunately at this particular juncture, we're just at the infancy of the proceedings.
Right, but the process is an odd process, right? It contemplates that there will be some kind of evidence taken before the decision is made. And in that context, there were depositions from which the judge decided that this was multi-level hearsay that wasn't reliable. And we're not in a position to overturn that decision, are we?
We also acknowledged again that we're at the very beginning of these proceedings. And
But for purposes of this motion to dismiss, you guys actually got more process than the statute contemplates. Instead of affidavits, you had depositions. The judge read the deposition testimony, and that's the conclusion that he came to, that it was, at this point, multi-layer hearsay with no person actually identifying who Jennings ever said this to.
But
what's wrong with that?
Well, again, we haven't been able to vet that entirely because of the odd nature of how we're approaching a special motion to dismiss. However, it goes to the issue of the motion to dismiss, the regular motion to dismiss. I still believe we have a very viable claim under the MCRA, and the judge found that because of the facts that have been alleged. There's been threats.
We're gonna have to leave it there. I'm sorry, Mr. McMillan, but your time has run out. Thank you.
We are live and on the record.
The next case on our list for hearing this morning is case number 2020 P59, Harry Churchill and another versus PMG Physician Associates PC and another. You may begin.
Good morning, Your Honors. Barry Duchesneau on behalf of the appellants in this case and the plaintiffs in the underlying matter. May it please the court. As Your Honor already indicated that you're familiar with the facts of the case, I won't take you through that. So, really the issue here, as you know, is whether or not the trial court erred in refusing to return the jury to deliberate after an inconsistent verdict and then grant an adder or set aside a verdict and order a new trial on damages. So first and foremost, as to the inconsistent verdict, this verdict was inconsistent because based upon the evidence presented, there was no way to find harm, which the jury found, based on this set of facts without ensuing monetary damage. If the jury believed the defense case, they would have to believe that Mr. Churchill's diagnosis of prostate cancer, and the allegations in this case was that there was a 2-year delay in diagnosing that. They would have to believe that his prognosis would have been the same in 2010 when the plaintiffs argued it should have been diagnosed as it was in 2012 when it was actually diagnosed. And they would have had to have believed that his treatment options would have been exactly the same in 2010 as well. The evidence.
I mean, isn't it also possible for them to conclude that while his prognosis is worse and his treatment options are fewer and less beneficial, that at the end of the day, neither of those declines creates any measurable difference in the outcome that he ultimately is going to face as a result of this condition?
So if we take that argument that the outcome of his condition is not measurable, well, then we would have to presume that the jury did accept the defendant's expert, Dr. De Silva's testimony that Mr. Churchill's prognosis, treatment options were all the same, or that they decided it wasn't measurable. So, well, no,
let me put a more precise point on it. They could have accepted some portion of the expert's testimony and rejected others, but ultimately concluded that while nobody likes cancer, some forms of cancer are unlikely to be the cause of your eventual death. They may have accepted the portion of the expert's testimony saying that there is no way outside of speculation to determine that the plaintiff's ultimate death would result from this condition, even though it now is incurable because it's slowly progressing.
So if we want to say that the jury believed that it's not the cancer that will ultimately cause his death, we have to take into account then what harm they could have found, because we know they found harm by answering that question right. So even if we do presume that, Your Honor, Mr. Churchill's that would be taking it in the light most favorable to the defendant, as we do have to do. But the two treatment options that everyone agreed were possible were a prostatectomy and hormone deprivation therapy. Mr. Churchill opted for the prostatectomy. Dr. De Silva, the defense expert, indicated that those two treatment options would be equally successful. There was no benefit to doing one over the other. Mr. Churchill opted for the prostatectomy. That surgery had to be aborted because once they got in there, the extent of the disease made it impossible for them to remove the prostate. So then he was required to go to treatment option number 2, the hormone deprivation therapy. And the only evidence presented at trial as to why Mr. Churchill had to undergo both of those grueling treatments and then experience the dismal side effects of both of those treatments is because that prostatectomy, the attempt to remove the prostate, failed due solely to the spread of the disease. And everyone agreed that the disease had spread during that point, during those 2 years.
Okay,
there was no doubt about that.
Counsel, I think I understand that argument as a matter of fact. Are you saying that the jury could not have found that the same thing would have happened had he been diagnosed in 2010? It seems to me that's your argument. Your argument is, as a matter of law on this record, that additional harm, having to go through 2 different processes, would not have happened had he been diagnosed in 2010. Is that your argument?
That is the argument, but also I think what is important on that note that you just made, Your Honor, too, is that this jury was very clearly instructed that they could not find Dr. Browning liable if the harm would have occurred absent his conduct. So they've already made a determination that Dr. Browning's conduct caused harm. So we can't say, there's no way
but
we
see,
have.
As Justice Green pointed out, we don't know what that harm was. And one potential harm, and this is why I think your brothers say in their briefs, there are many different possible scenarios that could have been in mind. Justice Green says one thing is they could have said, well, your prognosis is worse. You were harmed because your prognosis is worse because you didn't learn about this for 2 years. But that doesn't necessarily follow from that there is a compensable harm as you're talking about, which is, as a matter of law, you have to determine at that point that he went through 2 things he wouldn't have otherwise gone through. Do you follow what I'm saying?
I do. To come to that conclusion, the jury would have had to completely speculate it. It just wasn't in evidence. But
all of the things that I just identified were in evidence, weren't they?
Well, that his prognosis had worsened and it was going to cause his death, which if we assume in the light most favorable to the defendant, and I think what you're asking is, well, what if they decide it's not going to cause his death? But we know, and
because the evidence was that as of the time of trial, it was in complete remission.
So, well, no, it wasn't. He wasn't in remission. It had his PSA level at the time had become undetectable.
No, had become
PSA
undetectable.
level.
Well, I'm sorry if I used the wrong language, but the jury was confronted with a witness taking the stand whose PSA levels were normal. So, although, I mean, they're trying to sift their way through competing. They don't have to accept one or the other. They've got competing experts, right?
Also, the jury had expert testimony that would allow them to conclude that that his prognosis, though worse because it's incurable, did not mean that this condition was going to ultimately lead to his demise. So the question, I mean, sure, they found that there was harm, but there are lots and lots of harms they could have found Some of those harms are unquestionably compensable, and others may not be.
I think that with a 2-year delay in the diagnosis of cancer, to say is not compensable is just simply inconsistent with the evidence that was at trial. And
but there are cases, as you know, around the country that have found just that in circumstances where the cancer, in fact, I mean, nobody likes cancer. Thankfully, we are in a far better place today than we were 10 years ago, 20 years ago, 30 years ago. And there are many, many people who live healthy and productive lives managing their cancer. Juries, I think, are entitled to some degree of respect and sophistication in their understanding and their ability to listen to an expert who tells them that simply because you hear the word cancer, it doesn't mean that this man's life is ruined.
so I think there's 2 points to address there. Well, first of all, we know that he's on the hormone deprivation therapy now, which has caused his body, in all essence, to completely betray him. Weight loss, muscle mass, fatigue, hot flashes that he will be on for the rest of his life. And if I can, when I say, you know, well, couldn't they have found that all would have happened anyway? The answer is no. The evidence that was presented is that the reason the prostatectomy failed and he had to go to treatment option number 2 was because of the extent of the disease that had occurred in those 2 years. Dr. Browning himself.
Whoa. Because of the extent of the disease that had occurred in those 2 years. That, it seems to me, those last 4 or 5 words are critical. Where was that evidence and was it undisputed?
So Dr. Casper did in fact testify that the prostatectomy would have been successful without lymph node involvement. And the medical records indicate that when they got in there, they attempted the lymph node dissection and it was too extensive and they couldn't do it. That's the only evidence that was presented. There was no evidence that the prostatectomy wouldn't have been successful from any other source. So I would argue that there was no evidence for the jury to determine that. And the advancement of that disease that occurred in that time is Dr. Browning testified to himself. He testified that in 2012, which was at the time of diagnosis, Mr. Churchill came back. He now had a slow urinary flow. And Dr. Browning testified at that time that that was from a physical obstruction that had not been there in 2010. And then Dr. Brown also testified that he could feel the cancer in 2012, which he could not feel in 2010. And the jury accepted when they determined that he did in fact perform that digital rectal exam. So we have, that's the only source of evidence on that topic as to the prostatectomy. And
Well, the jury could also have developed the belief that that growth was present, but the doctor negligently failed to identify it at the earlier stage.
So, well, I guess you're asking if the jury determined that he did in fact do the digital rectal exam, but maybe he didn't feel it?
Correct.
So all witnesses indicate that once it has reached stage 2, which is where everyone indicated it was at that point in time, that it is palpable. Dr. Browning says it's palpable. Dr. De Silva said it would be palpable. So did Dr. DeCahan, the defense standard of care expert.
I understand that, but does that guarantee that it will in fact be detected?
I don't think there was any evidence that it couldn't be detected. They would, again, the jury would have had to have speculated that. I mean, Dr. Browning testified, I did it, I didn't feel it.
Can't the jury apply its common sense to know that a doctor performing that exam might make a mistake?
I mean, I don't think they can assume he made a mistake when all of the evidence.
But you're suggesting that they are required to accept it as a certainty.
More likely than not. I mean, that's the standard of care, is more likely than not. And everyone agreed that more likely than not you do.
No, because we view the evidence in the light. Well, okay, I'm not exactly sure how the preponderance applies to the interpretation of facts at the first exam stage. But go on.
Ms. Ducheneau, can I interrupt with another question and slightly different question? when the deliberating jury asked a question of the judge and he responded, wasn't it his response that at least implied that the jury could find negligence and causation and award no damages?
So the answer, I would argue the answer really, in effect, was not an answer. The question, in effect, went unanswered. They were referred back to their originally properly given jury instructions and told the determination of damages is left to your judgment and estimation as the triers of fact.
By not excluding that as an option, it left it open as a possibility, right?
Which
in
is,
response to that specific request?
if it's not against the weight of the evidence, it's sort of but it is in this case. You know, we can't presume, you know, why they asked the question. They can't, if they, you know, telling a jury yes or no is getting involved in their deliberations. You know, nothing objectionable happened until the inconsistent verdict came back. The jury instruction that they are the triers of fact and determination of damages is left to them was properly given in the original jury instructions, and I'd argue in almost every medical malpractice.
Don't you wish that your trial counsel had said, no, Your Honor, you have to answer that question no. On these facts, you must answer that question no.
I don't think that would have been a proper, if that had happened,
That's
I think
the argument you're making now. That's exactly the argument you're making now, that answer should have been given. On these facts, no, you must have damage.
But that is for an additor. That is for a post-trial resolution, and an additor is certainly permitted.
No, the jury is saying, hey, can we answer 1, 2, and 3 the way that we answered them and still come out with 0 damages? Answer from you is no, not on these facts, right?
I think that would have been improperly invading on the jury's province during their deliberation.
Well, that's precisely what you're asking us to do after they've completed their deliberations.
Because there was nothing, and the reason for that is because there's nothing objectionable until we know what the verdict is. And
well,
now
no,
we know
because
it's
if a question is determined as a matter of law and fact, it ought not to be put to the jury. And that's the way you preserve the claim, either by a motion for directed verdict or to an objection to a claim that leaves open a question of fact for their consideration that is on the record, not a question. You can go ahead and answer.
So, I apologize. I'm not sure I know what the question is.
You can respond. I just made a statement that you haven't preserved the claim. You can go ahead and respond.
So preserving the claim, it's the inconsistent verdict that we're appealing from. We're not appealing from the instruction given. There's no, despite what defense counsel has said, there's no objection to what the instruction was that's given. Nothing objectionable had happened yet. It was a reiteration of jury instructions that had already been given to the jury. So
I get it. Thank you. Which of you will be going first?
I will, Your Honor. May I?
You may begin.
Am I understanding correctly, you both represent the same client?
I represent Dr. Browning, Your Honor, and Mr. Briard represents Dr. Browning's corporation.
Okay.
Sued for vicarious liability. So good morning, Your Honors. Thank you for hearing our case this morning. First, I'd like to talk briefly about the issue of waiver that Your Honors were just discussing with counsel for the appellant. This jury, Your Honors, after a substantial amount of time of deliberating, came to the court with the question at issue in this case, which was, could they answer that causation question? Yes, but award no damages to either Mr. or Mrs. Churchill. Clearly, at that point in time, they were looking for direction from the trial court on that issue. Looking for the court to tell them whether that was a permissible thing.
Was the instruction that was given wrong?
Absolutely not, Your Honor.
The instruction that was given wasn't wrong, then how could there be a waiver? I don't understand.
Well, Your Honor, because
the judge said, I can't remember, but it's something along the lines of the damages are in your hands.
Correct.
If that's not incorrect, then how is there a waiver?
Well, because in this appeal now, Your Honor, the appellants are alleging that it's entirely impermissible to have a zero damages verdict if you answer the third question rather, yes.
Right, and we can address that on the JMOL issue, we can address that on the inconsistent verdict issue, but it seems to me on the question of whether there was a waiver, the instruction would have to be wrong. That's why I was asking the questions of your sister the way I was, which is, shouldn't you have said no? It seems to me your position has to be that the judge had to answer that question, no. I'm sorry. It seems to me what you're saying is they should have objected and said to the judge, you need to answer that question, no. And it seems to me that that's not right because the judge gave an instruction that was not wrong. There are instances in medical malpractice cases where the jury can come in after they found harm with a zero damages. Their position is on these facts, they could not do that.
Exactly, Your Honor. But I think in order to preserve the appeal, they needed to object to the court telling the jury expressly that, yes, you can come back.
No, the judge did not answer the question, yes. If the judge had answered the question, yes, then I think you might be right. But that's not what he said.
Well, he said it was entirely within their discretion.
He said, you decide the damages. I can't remember exactly how he said it, but he basically just tracked the jury instruction he'd previously given.
Right. He said it was left to their judgment and estimation. In other words, was telling them that, yes, they could do what they were specifically asking. It was within their discretion and determination. So I think that's a waiver.
So that's an argument that they should have at that point objected to the judge's instruction and said he must answer that question, no.
Yes, that's what I would say. So that's that issue of waiver. Seeing my time, I'm going to move right on to the second issue, which is really what the appellant rather has to prove under the circumstances of this matter at this point is that the verdict of the jury here had to have been a product of either prejudice or bias. And I don't think they can do that on this record. This jury deliberated for a substantial amount of time.
Do they have to show prejudice or bias? I mean, the argument we just heard did not address prejudice or bias at all. The argument we just heard was that no reasonable jury could have reached the conclusion that there was harm and then assign no damages given the facts that were undisputed or at least indisputable before the jury. That was the argument we just heard. It wasn't based on prejudice or bias or anything else.
Well, that's the argument we just heard, Your Honor. However, in the brief, what they made the point of expressly was that this jury had to have decided that they did not like Mr. Churchill and therefore gave him no damages. And that was the only reasonable, plausible explanation is the argument that they made. And what I'm suggesting to the court is that that simply is not supported by the record at all, given the conduct of the jury, given the fact that they asked two questions along the way. And frankly, on the sentinel issue on standard of care, it was really an issue of credibility between Mr. Churchill and my client, Dr. Browning, and they found and gave credit to Mr. Churchill's version. So it's hard to imagine that if they credited his recollection of the events, that they were just then going to turn as a matter of bias or prejudice and award him no money. It doesn't make any sense on this record. So what makes much more sense on this record, Your Honors, I would suggest is that prostate cancer is a very different animal. And in the prostate cancer setting, we have the Gleason grade. And that's vital to understanding this case because it was undisputed in this case that this cancer was a Gleason grade 9 from its onset, meaning that the very first time these cells ever divided, it was a Gleason 9 cancer. That is what drives prognosis in these cases, not the timing of diagnosis. And that was laid out very carefully by my expert, Dr. De Silva. So this jury very well could have accepted that argument and nonetheless found that there was some harm or injury in the form of perhaps emotional injury or upsetment at knowing that this diagnosis was made 2 years late. However, crediting the testimony that it didn't make any difference ultimately in the outcome for this patient, especially given the fact that we know he's done quite well because his body has responded.
What about the argument that your sister just made, which is this, as I understand it? And if I don't do it credit, I apologize. It is Had he been diagnosed in 2010, he would have undergone a treatment regime, which he actually tried in 2012, which would have succeeded. And therefore, he would not have undergone the pain and suffering of a second treatment regime, which he had to undergo because the cancer had advanced so much by 2012 that the original treatment did not work. What do you say to that?
So I think the answer to that is very straightforward, Your Honor. And I think it was within Dr. De Silva's opinion, which is that at that time, had it been diagnosed, it was still nonetheless a stage 3 cancer because of the grade 9 Gleason score. Consequently, even if the cancer had been removed by way of a prostatectomy, more likely than not, there still would have been the need for the hormone therapy because this cancer had already likely escaped microscopically because of the genetically aggressive nature of the cancer due to the Gleason 9 grading. That was all part of Dr. De Silva's opinion. So,
well, let me try to get that. So the prostatectomy, so the position of the plaintiff is the prostatectomy didn't work in 2012. Therefore, they had to undergo the second plan B, if you will, which is a hormone treatment.
right.
And you're saying there was evidence in the record from which the jury could have found that the prostatectomy wouldn't have worked in 2010 either.
Absolutely, because by its nature, it's a 3C stage at diagnosis, even in 2010, because of its grade being a Gleason 9, which means that that type of cancer can microscopically be outside of the prostate gland well before that can ever be detected, meaning that even if the prostate had been removed in 2010, it would not have cured him.
So what you're saying is not that the prostatectomy would have been unsuccessful, but even a successful prostatectomy would not have avoided the hormone therapy.
That's 100% right, Your Honor, because more likely than not, at that stage, unfortunately, even in 2010, it had microscopically left the prostate because the testimony of Dr. De Silva was more likely than not, even if he'd been diagnosed in 2010, he still would have had the same prognosis. In other words, he still would have had the same.
Well, did he testify that in 2010 the prostatectomy would not have averted the need for hormone therapy? Did he testify to that?
I don't remember if he was specifically asked that question, Your Honor. I would have to go back and.
Well, I'm looking at the pages that you've identified for what I think is the critical testimony, and it's not there. I do see he would have his treatment options were the same. I see that. But I don't see what you just said here. And so I think you're asking us to infer it from various other things he said at other places.
But I don't think so, Your Honor, because subsumed in that statement is that he absolutely opined that the prognosis would have been exactly the same, meaning that even if you'd done a prostatectomy in 2010, it would not have changed his outcome. So that,
yeah, but that's a different story. He's not talking about outcomes. Sorry.
I think that's what he was talking about, Your Honor. And I think.
Sorry, Judge Green.
No, I was just saying it's not a question of ultimate outcomes, but also the treatments that would have been administered. And the critical question, the argument that you were just making is that he would have had to undergo the hormone therapy even following a successful prostatectomy. And Judge Englander is questioning the support in the record for that assertion.
Well, I think it's in there because he would have absolutely, because of the grade of this cancer, not been cured by the prostatectomy. So the treatment for that is to then use the hormonal therapy. And
well, we'll have to look for that, and we'll hear from your brother on any additional questions. Thank you.
Thank you very much.
Thank you, Your Honor. Chad Briard for PMG Physician Associates, PC. May I proceed?
Please.
Thank you. And yes, just to clarify, I think the initial question at the beginning. So I represent the practice of Dr. Browning. So we're jointly presenting today. I'd like to just add on a few things to Brother Counsel's, what he was just saying, but also, there was some question from the court about this reference of bias and why are we talking about bias? And, plaintiffs, the appellant's brief, page 50, they specifically say the only reason that the jury, the only explanation for why the jury could have decided as they did was bias, and they cited to Turnpike Motors case in support of that. So that's why I believe Brother Counsel was making the point that there.
It really doesn't matter, does it? I mean, either the evidence is sufficient or it's not. And whether there was a motivation that was from an improper source is sort of icing on the cake. But the ultimate question is whether there was evidence to support the jury's verdict or not. Right?
Correct, Your Honor.
Okay, let's stick to that question.
Okay, so turning to the issue about what we just heard about the prostatectomy and also the failure of proof on damages. In essence, I think if you look fairly at plaintiff's brief as well, the argument has been that this cancer went from curable to incurable. And that's plainly what they see the harm is. But I think what we're talking about now is the manifest different ways that the jury could have credited there being potential different sorts of harms. And
do the defendants concede that in the 2 years from 2010 to 2012, the cancer went from curable to incurable?
No, absolutely not. The testimony was directly disputed by, we provided affirmative evidence through Dr. De Silva, but in some ways, actually plaintiff's
own expert. It was always incurable. That's essentially what your brother was just saying to me. It was incurable from the start because it was a Gleason 9. It was going to escape. There was no way you were going to avoid hormone treatment by surgery.
Correct. But Your Honor, I would also point out that in some ways, Dr. Casper also conceded the point on cross-examination as well by being unable to determine the supposedly the fact that this or his contention that the plaintiff would ultimately die of this cancer. He certainly on cross-examination wasn't able to conclude that.
That seems to me to be a different issue.
Most significant diagnosis.
But that's it. The question of whether he's ultimately going to die from the cancer seems to me to be a very different issue from whether or not the treatment has to be the same. I mean, you can die from all kinds of things, right? And you guys are steeped in this and I am not, but it seems to me that one of the most practical things that you could be saying is his age is X and at some point something else might take him because the cancer progresses so slowly. And isn't that the thing with prostate cancers?
Well, I mean, many people die with prostate cancer never knowing they had it, right? So, right, but exactly. I mean, I think the question for the jury though, and what we fairly put in front of them was opinion through Dr. De Silva that the treatment, the outcome, and the prognosis was the same. So I think getting to your point as to how he addressed the prostatectomy, he at least in that general way, very clearly said he thought the treatment would be the same.
Well, he said the treatment options were the same, which is not the same thing as saying the treatment would have been the same. And it seems to me your sister is really, she may have other arguments and maybe we're wrong. Maybe I'm wrong. I am wrong just to be focusing on that. But one of the things she's saying is whether the treatment options were the same, the treatments were different because in the 2 years in between, something happened. That's her argument. And that we need, and that as a matter of law, therefore, there was damage. And you say to that, no, our expert said the opposite?
Our expert said just as Brother Counsel explained, very clearly stated that back then, even microscopically, the cancer was outside of the prostate. So therefore was going to need the same hormone therapy regardless. That part is unchanged.
And where would you point me? Is there, and this may be unfair, but is there a place in the record where your expert said that you would point me to?
In 6 seconds, I think it's impossible for me to find it in the transcript, unfortunately, Your Honor.
Fair enough, fair enough.
I think it is generally stated there.
We are live and on the record.
Proceeding to the third case on our list for hearing this morning, case number 2019 P1740, Charles Matter and others versus Andrea Cabral and another. You may begin.
Good morning, Your Honors. May it please the court. My name is Elizabeth Sine, and I represent the plaintiff appellants in this case. Workers injured in the line of duty by inmates engaged in violent acts. At this time, I'd like to request 1 minute for rebuttal.
There is no rebuttal.
Understood. This case concerns the utter disregard of the appellant's constitutional and statutory rights. First, the record demonstrates that the defendant appellees failed to abide by elementary requirements of procedural due process, as well as the Massachusetts Pension and Retirement Statute. And further, there's a genuine issue of material fact as it relates to the workers' compensation retaliation claim. And therefore, this court should reverse and remand. Turning to my first argument, the retaliation claim. Chapter 152 provides that no employer shall discharge or otherwise discriminate against an employee for exercising their workers' compensation rights. Here, the only disputed element of the prima facie case under this statute is causation or intent.
Counsel, on that point, let me interject a question if I could. Your argument on that point seems to rely heavily, if not exclusively, on the content of the termination letters. So my first question is there anything in the record other than the content of those letters themselves that supports your position that the termination was for the purpose or in retaliation for having sought and received workers' compensation?
Yes, Your Honor. I would direct your attention to page 368 of the record. That's Sweeney's deposition. And I would also direct your attention to the language or the requirement of Chapter 32A, Section 8A itself. So first, the statute required the GIC, the Group Insurance Commission, to charge the department the cost of insurance for employees, who are on a leave of absence in excess of 1 year. Now, if you look at Sweeney's deposition on 368 of the record, and I'll read it by its quote. The department previously had a policy prior to 2012 of people could be on a leave of absence for up to a year. But we did not include people on workers' compensation in that group. When we were under the umbrella of the City of Boston, not the Commonwealth, funding for health insurance was supplied to us in the operating budget. So the department used to carry the employees on workers' compensation leave indefinitely until they retired. Your Honors, when you pair the requirement of the statute with Sweeney's deposition statement, this means that those on workers' compensation and only those on workers' compensation would be a new charge to the department going forward.
Isn't another interpretation that anyone that had been out of work for a year would be a chargeback, whether or not they were on workers' compensation?
Correct, Your Honor. However, that wasn't the policy of the department. They were already doing that. So when it came time for
But
the
they
charge,
weren't. So, I mean, that argument was well constructed, but they weren't being discharged even under the way you read it because they had asked for workers' compensation. In fact, they'd avoided discharge because they'd asked for workers' compensation. And then when the rules changed and those costs started getting visited on the budget of the sheriff's department, then they changed the rule. That's not motivated by their workers' comp. That's motivated by the change in the rule, even as you read it to us. Am I missing something?
Your Honor, I'd like to first point out that the district court, the Federal District Court of Massachusetts in Downs, while recognizing that Massachusetts courts offer little guidance on the applicable standards of determining when an employer has acted because of the employee's assertion of those rights, it concluded that workers' compensation rights must merely be a motivating factor, not the sole motivating factor. So the cost argument.
But this testimony doesn't appear, to my eyes at least, to suggest that workers' compensation played any role in the motivation. It did affect their status as being part of a group that previously would have been allowed to remain indefinitely, and after the change in the insurance chargeback, they were no longer given that additional benefit. But I understand that you could have multiple motivations, but this is not this has no bearing on the motivation of the sheriff's department. It has to do with their status as part of a group.
Well, essentially, Your Honor, the cost issue is so necessarily intertwined with their status as workers' compensation employees and the effect that their status as workers' compensation employees had on the department. Essentially, the cost of workers' compensation was going up for the department because they now had this new charge due entirely to workers' compensation employees and their health insurance.
But
Well,
isn't the question for us to determine what triggered the decision to terminate the employees? I understand your argument is the fact that they were on workers' compensation, but many of these officers had been receiving workers' compensation for years.
Correct.
Doesn't that undercut your argument somewhat?
Well, it's a factor in the argument, but it wasn't until the cost of those employees became too expensive or unanticipated to the department that they essentially cut them loose. Basically, the cost of workers' compensation was going up for them. The department didn't want to deal with it, and they cleaned house. And Your Honor, it's not for the court today.
It wasn't the cost of workers' compensation that went up. It was a cost associated with workers' compensation that went up. It was the cost of health insurance that meant that they could no longer carry workers who were on workers' comp beyond a 1-year period with the same cost neutral posture that they did previously.
Right. As applied to the department's particular policy that was in place right before the statute became applicable, it was fine to carry those employees, but as soon as they became costly, the fact that their status as workers' compensation employees became costly, that's what motivated, or that's at least a factor that motivated them to terminate the employees. And basically all these issues.
It was a suspension of cost neutral health insurance that caused them to remove what previously had been a benefit extended uniquely and solely to workers out indefinitely on workers' comp.
Correct, but the department didn't apply that policy to workers' compensation employees. They didn't apply it until they came more costly.
Right, they gave them a break because it wasn't costing them any money. Then when it cost them money, then they stopped giving them a break. Can you?
I just not want to notice the timer switched on as we were. Okay, there we go.
Where in the record is the letter itself that you rely on? Because I could have sworn I saw it, but
The termination letters, Your Honor?
Yes.
They're all located on pages 145 through 160. And Your Honors, I would submit to you that these letters, Sweeney's deposition, the new requirement of Chapter 32A, Section 8A, all of those considerations should have gone to the jury. This back and forth we're having right now is evidence of the fact that there's a genuine issue of material fact as to intent. As this court
Well,
stated in
you say that, but at least with respect to 2 of the officers, there isn't any mention with respect to Officer Shea and Officer Carrasquillo, even in the body of the letter, there's no mention even of workers' compensation. How do you get over the rail with respect to those 2?
Your Honor, for Shea, I would direct your attention to page 159, the letter dated July 23rd, 2013. That does cite the receipt of workers' compensation benefits. Regarding Carrasquillo, I would direct your attention to page 224 of the record, where Officer Tucci states that the grievant had been terminated by the department while out on a work-related injury approved by workers' comp. In addition, the findings cite the fact that he had been receiving workers' comp. So while the letters don't say it, it doesn't mean that it didn't happen. And Your Honor, with that, I'd like to turn to my next argument, the requested relief from Mandamus. This relief is available to secure the performance of a public duty at the instance of any person legitimately concerned in having it performed. The public duty that is clear-cut here is Chapter 32, 5B. It essentially required the department to put together a team to determine whether these employees were capable of returning to work And if not, they should have been retired. Administrative
Doesn't
termination is not an option.
doesn't relief under mandamus require you to exhaust all of your administrative remedies first?
That's correct, Your Honor. However, there were no administrative remedies for these plaintiffs to exhaust.
Well, you were at one point in arbitration and withdrew that.
The union withdrew it, not the individual employees. The union represents the interests of the group, all employee members, not these individual employees.
Well, in this case, wasn't the union representing each one of these individuals?
That's correct, but they could have withdrew arbitration for any reason. The plaintiff.
No, but the right to arbitration is not a right held by the union. It's under a collective bargaining agreement that extends benefits to each of the individual employees. And while the union was acting as representative in those in that grievance and arbitration proceeding on behalf of the individuals, you can't separate the action of withdrawing the arbitration from the individuals whose claims were subject to arbitration.
Even still, Your Honor, the subject of the administrative remedy that cannot occur is retirement matters. And on page 173 of the record, the CBA specifically states any matter subject to the jurisdiction of the Civil Service Commission or any retirement board shall not be the subject of a grievance or arbitration. That's what we have here. There's no contractual language in the CBA concerning.
So help me with what your argument is, because I understand the point, but only partially. You're saying that what should have happened rather than termination? What should have happened? What should have happened? You cite Chapter 32, Section 5B.
Yep.
What should have happened?
Well, first, the department should have had this team together to determine whether they could be rehabilitated to return to work, or if not, they should be retired pursuant to accidental disability retirement, and they would have received their benefits that they were due as a public employee, as a tenured public employee. On page 93 and 95 of the record, you'll note a body admits that the department does not have this early intervention or rehabilitation plan. Administrative termination wasn't an option, and we asked the court to enforce that fact today. And moreover,
administrative termination wasn't an option. Well, and this is a question I think that goes to both this argument and the argument about the constitutional.
Yep.
What should have happened? I mean, the note, your clients were all given notice, and in each one of the notices, I think there's an indication that they're incapable of returning to work. Every one of your clients was asked, aren't you incapable of returning to work? And as I understand it, with the exception of one, none of them said, I can work now. So what is it that, I mean, so it seems to me this, you're saying Chapter 32, Section 5B wasn't followed because the first part of it would have been to determine whether they could return to work. Well, every one of your clients was offered the opportunity to return to work and said no, with the exception of one. So I'm struggling to figure out what was missing here.
well, they should not have been terminated. They should have been provided the opportunity to retire, which the department has the opportunity to implement. They would have received their retirement benefits. They would have been with health insurance. In this case, we have a huge gap of health insurance coverage where the employees were paying an enormous amount in COBRA insurance. This is precisely why this statute is in effect. It's to avoid situations that happen to these appellants. And moreover, you'll note on page 315 through
They
320.
should have been offered the opportunity to retire.
Correct.
I mean, how is that inconsistent with termination? I'm missing something that may be obvious to you. They are
Well,
terminated with a note that says, soon as, if you improve, you can always come back. Why is the termination inconsistent with them retiring?
Well, retirement provides a whole different set of benefits to
So
them.
once terminated, they can't retire?
Close from retiring.
I'm sorry, Your Honor.
Why were they foreclosed from retiring by the termination? I think is Judge Englander's question.
Well, the department made that decision. The department was obligated to implement their retirement ability or rehabilitate them. They didn't, that's not an option in the statute.
They've said they can't be rehabilitated, and Judge Englander's question is that your argument seems to rest on the premise that because they were terminated, they cannot retire. It's not clear to me, and presumably it's not clear to Judge Englander when he asked the question, that is in fact the case. That it's not clear to me that termination precludes them from being able to retire.
Your Honors, I see that my time is up. May I address your question?
You may answer.
So the issue is that they were retroactively retired and then they did receive retroactive pay, but they did not receive their health insurance. The damage was done at that point. So no, they weren't precluded from retiring, but the whole timeline of events was all at the behest of these injured workers because the department chose to admittedly not follow a mandatory early intervention plan.
I think we're gonna have to leave it there. Thank you for your argument.
Thank you.
Attorney Forbes, unmute yourself, please.
Your Honor, good morning, may it please the court. My name is Alan Forbes, and I represent the two defendants in this case, Andrea Cabral and Stephen Tompkins. The undisputed evidence in the summary judgment record was that each of the plaintiffs was physically unable to do the essential functions of their job. And it's also undisputed that each of the plaintiffs, save William Gunning, applied for accidental disability retirement benefits and received those benefits. The terminations were done shortly after, a few weeks after, the department notified the unions that we would be terminating people who, and this is on 212 of the record, employees on medical leave of absence who are receiving work comp benefits will not be terminated unless an administrative judge adopts medical documentation indicating an inability to return to their previous position or an offer of accommodations has been made and declined. So the department did not set out, and that's undisputed, the department did not set out to clean house and terminate every single person who was receiving work comp benefits. The letters all say that the variation in the letters essentially is around whether or not the benefits are under Section 34 or Section 35 of the work comp statute. But the letters simply say, they note the fact that the employee has been on workers' comp benefits, which sets the stage for the following proposition, which is that you have either persuaded an administrative judge that you can't do your work, or you have submitted to, in the case of Botticelli, documents to the retirement board saying that you should be retired under ADR benefits. And so that was undisputed. Also undisputed was the fact that the department would incur this additional charge, which Sweeney estimated to be about $140,000 per year to continue to hold people on the rolls. And so that was the reason for the termination. I would note that as the Superior Court's memorandum of decision points out, there was no evidence that payment of workers' compensation benefits adversely affected the Sheriff's Department budget in any way. And
Okay,
as
so can we move, unless my brothers have a question on the worker comp based count, the retaliation count, can we move to the other two issues that we have in front of us? Your sister says you failed to follow Chapter 32, Section 5B, and that there's an opportunity for mandamus relief with respect to that. And honestly, as you can probably tell from my questions, I'm struggling to determine what the relief is that would be appropriate under the circumstances. But did you fail to follow Chapter 32, Section 5B?
that's true, we did not create those teams that the statute contemplated.
So why doesn't she have a viable claim for mandamus?
Because administrative remedy available to the employee says under the CBA that if the department violates the terms of the agreement, the employee is entitled to be made whole. And made whole is always determined at an arbitration. And it includes things like lost wages, lost benefits, lost pension contributions.
Your sister cites language which seemed to fairly clearly say that a claim based on retirement would not be arbitrable.
But there's no evidence that the department opposed that. And in fact, these claims were.
There's no evidence that the department opposed what?
Opposed a make whole remedy, that these arbitrations were moving along their normal path until 2014, when essentially the plaintiffs in this case had to determine whether or not they would pursue a remedy in the administrative side or on the legal side.
But the question is a different one, which is that the claims associated with retirement were not within the aegis of that arbitration proceeding.
So that's true, but then we get to what's the harm? What happened as a result of this? You have people who on the date of their termination had been determined, and I'm not making a judicial estoppel argument, but I am saying it had been determined in another forum that these people cannot do their work. They're not candidates to be rehabilitated to come back to work. And except for Luther Miles, every one of them went out on accidental disability retirement.
So then they should have gone into retirement, and that was not, and the statute was not followed. And you're saying the claim should be dismissed because
the plaintiffs were in no way damaged by the violation of the statute, and the statute doesn't provide a right of action either.
Because, well, the statute doesn't provide a private right of action. That's an interesting question, not one that I saw in your brief. Maybe that's related to the same thing as saying there's another, well, no, the argument with Mandamus is there's no other remedy.
But well, that would flow from the fact that there's no private right of action. But what do you say, aside from those procedural questions? I want to get back to the practical effect of this, because what I heard your sister saying was that there is a very significant injury that they suffered as a result of the failure to follow that procedure, and that is that they lost their health insurance. That's a big deal, isn't it? Is it true?
It is a big deal when a person loses their health insurance, and that happens to people who are terminated every day.
But
if they're obligated to be retired, maybe, I don't know.
If the department had followed the protocols that they were supposed to follow, they would not have lost their health insurance. At least they would have been able to retire in the ordinary course. They would not have lost their health insurance. At least that's your sister's argument, as I understand it.
I don't believe there's evidence, or was evidence before the motion judge, that there was a quantified economic injury as a result of losing health insurance. It's certainly an inference that can be drawn when someone has health insurance and they lose their health insurance coverage. I don't believe that was quantified for the motion judge. So the record
the motion to dismiss, right? I mean, isn't there an inference that if you lose your health insurance, that's going to cost you money?
This was
it's a summary judgment. Yeah, you're right. Sorry, I apologize.
Mr. Forbes, can I interject a question here? I'm looking at Judge Ullman's decision, particularly on the count requesting mandamus relief. And he says that plaintiffs could have challenged their termination on the grounds that the department failed to adhere to the procedures set forth in Chapter 32, Section 5B, by way of grievances and arbitration. I thought what I heard you saying was that, in fact, under Chapter 32, Section 5B, arbitration is not available.
So we have not made the argument that that Judge Ullman spelled out in his discussion of the count of mandamus.
Well, are you saying that are you agreeing that Judge Ullman, or at least that sentence within his decision, was incorrect?
I wouldn't say that it's incorrect. I just don't see enough analysis there to say whether or not Section 5B it's not fleshed out. It's a one sentence reference to the applicability of the statute.
But your sister argues that, or has asserted that under the CBA, the question of retirement was not subject to grievance and arbitration. If that's correct, then Judge Ullman's sentence is in fact demonstrably incorrect.
I would concede that.
Okay.
All right.
Let's assume that we conclude that, or at least that we conclude that that sentence within Judge Ullman's decision is incorrect. What's the proper remedy?
Again, I believe there is no remedy required here because of the make whole, when you have retroactive retirement under the ADR statute, the employee receives everything that she or he would have received up until the date of disability. So
Including health insurance.
yes. So if you're at the retirement board in 2021 claiming I'm disabled from an injury I incurred in 18, then the remedy comes with you get a payment, you get a lump payment from the retirement board to make up for what you missed until the date. So, and that's why awards on the ADR side say he's retired effective, and that it's always backdated to the date of disability.
Well, I didn't understand that, and it's because you live in a world that I don't. If it's on the ADR side, what does that mean? I thought your sister, here's my problem. I thought your sister said they don't get health insurance now. Then I thought I heard you say, oh yeah, they're getting health insurance. And I'm trying to reconcile those two things.
I apologize because I do live in a somewhat strange world, Your Honor. You have, when a person is vested, and this is not in the record, but when a person is vested in the state retirement system and they receive a pension, then part of that pension includes the entitlement to the Group Insurance Commission funding for their portion of health insurance. So the Commonwealth is paying a piece.
So is your sister wrong when she says her clients didn't get health insurance?
I would say that that's not in the record. And yes, my sister is wrong about that, that ultimately they were paid for that. It wasn't as, essentially these terminations speeded the plaintiffs along to where they would have been eventually. And because they were made whole at the end of the day by the retirement board, there's nothing to do in terms of mandamus.
But how do we
assume for a minute that we were persuaded by that and wanted to adopt that argument? Where do we find support for it in the record?
Well, there's no discussion in the record about what benefits accrued. I suppose it would have to come from the disability retirement statute and the ordinary retirement statutes.
So, thank you, counsel. Appreciate your expertise and your candor. Let me ask another question. On the due process issue, I was teed up to ask these questions of your sister because I think you set them up in your brief. If there had been a post-termination hearing here, the issue would have been what?
So that goes right to the heart of the economic necessity piece of the procedural due process cases, where we're concerned in other cases with misconduct, dereliction of duty, severity of punishment, all those sorts of things. A hearing is well suited to determine that. There really was no dispute. And I would point out, Your Honor, that there were post-termination hearings. They're called step 2 hearings. They're done within the department, and it's the last stop before the employee claims, demands arbitration. And so there really would be nothing to talk about insofar as.
Because the allegation would have to be, I was terminated improperly. And the position of the state would be, no, you weren't. You haven't worked for a year. Our policy is if you haven't worked for a year, you're terminable unless you can return to work. You agree you can't return to work. And that was established through a notice process. Am I right? I mean, each one of these letters said, hey, if you can work, come on back.
That's exactly right.
Okay. Thank you.
Thank you. If the court has no other questions, there's nothing I need to add at this point.
The court. A very practical question exists here on appeal. How does one negligently misrepresent his present intention to do anything in the future, let alone to pay wages? This question is not answered by a review of the evidence that was presented at trial. And for that reason and more that I will touch upon, the Superior Court erred in denying the defendant's motion for directed verdict.
Did you make that argument on your motion for directed verdict? Exactly as you just framed it, you didn't make that argument, did you?
I did not, Your Honor, not exactly as it is framed.
Or even, I mean, I don't want to hold you to the precise language, but I read your directed verdict motion and it didn't really say, hey, because this is a forward-looking statement of present intention, you can't have a negligent misrepresentation claim for that kind of statement. You didn't say that in the motion for directed verdict. Does that mean it's properly before us?
Your Honor, I acknowledge that was not stated in those exact terms. The argument that was made was more general in that there hasn't been sufficient evidence of the misrepresentations, as well as I moved for directed verdict based on the other counts as well, and in particular with respect to the damages portion that I thought was lacking when the plaintiff had rested its case.
But the mere fact that you made an argument directed to the sufficiency of the evidence, I mean, I think you have an obligation to explain why, right?
Your Honor, I certainly see the point. I think in the context of the motion that was filed, that was presented orally at the conclusion of evidence, as you see the colloquy between the court immediately had diverted to, well, this case is really about the Wage Act claim. You know, I think I'm going to reserve on the negligent misrepresentation claim. I see, you know, I'm not sure that I have the evidence for that portion of it. Actually, I don't believe you specified negligent. I may have misspoken there, Your Honor.
Do you know where is that colloquy in the transcript? Do you know? If you don't know right offhand, then move on, because I know you have a lot of things to touch on.
Yes, Your Honor, I do not know right offhand.
Okay, thank you.
So the representations that are at issue in this case really break down to two different classifications, but are essentially the same thing. The first is that the defendant Doyle in Doyle Engineering had misrepresented its intention to pay Mr. KASSERIS $28 per hour for every hour that he worked. The second misrepresentation claim is based on Mr. KASSERIS's version of the world, where he claims that Mr. KASSERIS told him he would, quote, take care of him. Now that particular representation takes a number of different forms through Mr. KASSERIS's testimony, but regardless, both relate to payment of wages and whether Mr. KASSERIS would be paid for not just the hours that he was going to be working in the future at that rate of $28 per hour, but whether he would be paid for hours that he claims to have worked in the past for which he was unpaid.
Mr. Sullivan, let me interject a question on that. That's with respect to these repeated assurances by Mr. Doyle regarding payment to Mr. KASSERIS. You and I might disagree as to the meaning of those assurances, but if the evidence is viewed in the light most favorable to Mr. KASSERIS, as it must be at this point, why couldn't a rational jury assume that if those assurances were repeatedly made over time, and those assurances then did not come to fruition, that the assurances were false or at least negligent when made?
Well, I think there is a distinction there between being intentionally false versus being negligent. The jury found that there was no intentional misrepresentation. With respect to finding that there was a negligent misrepresentation, for example, yeah, I'm going to pay you, yeah, I'm going to pay you, where, you know, the jury finds that, yes, the defendant had the intention to pay him in the future, but that was not possible at that time or something like that. We don't have the evidence for that. The fact that Mr. KASSERIS claims that was a repeated claim does not mean that each time it was repeated, it was false, or that the defendant was negligent in saying it and should have been more careful, knowing that he would be unable to make that payment.
Well, it turned out to be false because he didn't get paid. The question of whether it was negligent, it seems to me, then it turns on whether he didn't exercise appropriate care in assuring that it would be true.
I don't believe that the standard of care is to make sure that something you say comes true, Your Honor. I think it's that the words you say are true at the time you
the
represent.
standard of care is to use reasonable care as to the truth at that time.
Correct. And especially in circumstances where a reasonable person in the circumstances would anticipate, would understand that the person to whom the statement is made would rely on the statement.
Correct, Your Honor. So what we don't have is evidence that at the time Mr. Doyle made any of these purported representations, that he had information that would have led him to the conclusion that, in so speaking, he was not adhering to the standard of care.
Well, wait a minute. My understanding of the record, and I have not reviewed it exhaustively, I have not read the full transcript, but my understanding of the record is that there was a fair amount of evidence suggesting that the company had some cash constraints. And part of the reason why he was stretching out these payments was because he was not able to make them at the present time. Viewed in the light most favorable to the plaintiff, why could a rational jury not conclude that it was fair to expect Doyle to know, to understand that that the statements he was making would be false, were false when made?
Your Honor, I would not agree with that characterization of the evidence. There was, after the plaintiff rested his case, there was testimony from Mr. Doyle where he acknowledged there were instances that he would, in fact, dip into his own personal funds to fund payroll for Doyle Engineering, Inc. I do not believe that a reasonable finding or inference from that testimony would be to conclude that the company was unable to afford whatever hours Mr. KASSERIS would actually.
But this gets back to to Judge Englander's question at the outset, because to the extent that that you're arguing that all of this is fair game on appeal, even though you didn't make it as part of your or your directed verdict or even your JNOV motion, that's one question. But it seems to me it's a little tough to suggest that we are to ignore the evidence in the entire case at this stage when you didn't make that argument to the trial judge at the directed verdict stage.
I would submit, Your Honor, that obviously at the time of the initial directed verdict, the judge had the record that the judge had.
But he didn't have this argument.
I'm sorry?
He did not have this argument. So the question now is, why should we not be looking for this, even to the extent that this argument is fairly preserved? Why shouldn't we be looking at the entirety of the trial record rather than simply at the plaintiff's case?
If Your Honor does choose to look at the entirety of the record, I would still submit that the testimony that was adduced at trial did not support a finding of a negligent misrepresentation, and that Mr. Doyle, certainly the jury found that he didn't know that he didn't have the ability to pay them, because if he had known it, that would have been an intentional misrepresentation. The should have known portion, I do not believe is supported merely by the fact that there were instances that he had to dip into personal funds to make payments, or by the fact that he had made payroll payments.
What about Judge Kinder's question? Actually, let me ask a different question, although I think Judge Kinder's question was an excellent one. It's already been asked, right? This is my question, and I've now forgotten it. Oh, was there agreement as to the misrepresentations that were allegedly actionable. You've identified two, and as I read the briefs, they kind of circle into one misrepresentation being that he would pay him all the wages, he would pay him for every hour he worked, or he would pay him for more than just the hours that he had paid him before. And the second one being, quote, "I'll take care of you."
I would submit those were the two that were put before the jury as the misrepresentations, Your Honor.
How were they put before the jury? I don't think they're in an instruction. These are the representations that they allege. How do we know that that's what the representations are?
We only know that, Your Honor, but based on a review of the testimony, the opening arguments, the closing arguments. We don't have it in a crystallized form as it was presented to the jury. Does that answer your question, Your Honor?
It does.
I would like to just speak briefly about the actual evidence that supported those claimed misrepresentations. An actual review of Mr. KASSERIS' testimony will not find him stating that Mr. Doyle, in fact, made a representation to him that he would pay in the future for hours that he had not paid for in the past. Instead, it is Mr. KASSERIS' testimony that he understood that to be what was intended based on a conversation, as opposed to what was actually said. I think there's a distinction to be made throughout Mr. KASSERIS' testimony between what he assumed versus what was represented. And I would submit that the jury didn't have a reasonable basis to find a negligent misrepresentation. Now, seeing as my time is ticking down here, I would like to just speak briefly about the issue of the damages as it relates to the motion to amend the judgment. The damages in this case were awarded at $44,000 based on the negligent misrepresentation claim. The Wage Act claim was presented at question 1A. It was not presented in the context, do you find that the defendants violated the Wage Act? If so, how much were the damages? Rather, it asked the question specifically whether do you find the defendants failed to pay all wages due to the plaintiff from April 18, 2013 through September 2015? And the answer to that question was no. The only claim here in this case is for wages. If the jury finds in response to question 1A that wages were not, there was no failure to pay wages, and we're not talking about any other defenses to the Wage Act, for example, failure to meet the condition precedent by sending a letter to the Attorney General or anything like that, then they necessarily found that there was no unpaid wages. How it is that we have a damage ascribed to the negligent misrepresentation in that context, I do not understand that.
Well, so let's talk about that, because it seems to me that's the nub of the problem. So the jury specifically found that he'd paid all the wages. Could the jury determine from the evidence that he'd promised to pay something else in addition to wages?
I don't believe that. I don't think that evidence is in the record, Your Honor, that there's any other thing. For example, he doesn't allege that there was an agreement to give him profit sharing. He does say, I assumed maybe he'd make up for it.
The allegation is he said, I'll take care of you.
Correct.
And let's take that one. I understand you have an argument that that's not actionable.
And not precise.
For a variety of reasons, one of which is that it's simply too vague to be actionable, right?
Yes, Your Honor.
If passing that point, could the jury have said, well, he only got paid $40,000 for 3 years of work, roughly, I'm just roughly, and we find that he did make these statements, I'll take care of you, and he made them, as Justice Kinder points out, on multiple occasions. So we think that that means he would have given him twice as much as he actually gave him. What's wrong with that? Leaving aside the question of whether it's actionable.
I don't believe that the jury doesn't have support for that damage amount. There's no, the only thing in front of him is wages. So I don't think the jury can then decide, well, wait a minute, maybe he should have reimbursed him for certain expenses. Maybe he should have given him 20%.
Didn't the jury have before them evidence from the plaintiff that he had worked more hours than he got paid for, and that he'd been working roughly full time?
The jury had evidence of that, but the jury found that he did not work more hours than he had paid for, because the Wage Act claim is strict liability. And by finding that there was no failure to pay wages, they necessarily found he was paid for every hour he worked.
Is that right?
In terms of the strict liability for Wage Act?
Well, but I'm not, that's sort of the nub of the assumption, is that the jury's finding the defendant did not fail to pay all wages due means that he was paid for every hour he worked, or every hour he was entitled to be paid for?
It would be for every hour that he was entitled to be paid for, except because there's no, which also means for every hour he worked, because there was no testimony that he had agreed to volunteer for a certain period of time or anything of the like. And I under the Wage Act, I don't even believe he could have agreed to volunteer for a certain portion of the hours that he was working. If you don't pay the hours, you're liable under the Wage Act. It's strict liability.
Attorney Sullivan, your time has expired. I think we'll have to leave it there.
Thank you, Your Honor.
Hear from Attorney Tinsley, please.
Thank you, Your Honor. A lot of what I have to say has already been covered in some fashion, often in the form of questions from the bench. So I'll try not to be too duplicative, but I think what's happening here is, well, let's start with the idea that you cannot negligently misrepresent your own present intention. I think, again, as a matter of law, that's just not the case. Now, conceptually, how we understand and maybe even form an image in our minds of what it would look like to negligently misrepresent our own present intentions, it might be somewhat more difficult to conceive, whereas other offenses against the law are perhaps a lot more straightforward and conceptually clear. But the fact of the matter is, the law recognizes a cause of action here for negligent misrepresentation, and you can be liable for negligently misrepresenting any fact if it causes injury to the party who reasonably relied on it. And your present intentions are facts just like any other facts. They're susceptible of proof, and where there is sufficient proof, you can carry your burden on a claim for negligent misrepresentation. And that's what happened.
Why isn't this a claim for promissory estoppel rather than a claim for negligent misrepresentation? I mean, you literally use the word promise in your brief over and over again. It seems to me that your claim is a contract claim, not a tort claim. Now, having said that, I'm not sure that matters. There were no objections to the way the case went to the jury. I understand. So, but it just seems to me this is a case about a promise on which he detrimentally relied.
I see Your Honor's point, and I think perhaps I could have or should. Had I argued it that way, I would have argued it in the alternative, though. I wouldn't have excluded the negligent misrepresentation claim, but in hindsight, maybe I should have added a promissory estoppel claim. I accept that.
Can we back up to where your brother ended his argument? Is it true that the Wage Act would have meant that all of your client's hours spent on behalf of this defendant had to be compensated? That's the way I heard what he said, that basically, given the Wage Act, if your client had worked more hours, he was entitled to be compensated for them.
It's a good question, Your Honor. I think in part it hinges on the terms of employment between the parties and some of the overall context, I think some of the work that Mr. KASSERIS was doing for which he did not receive payment, not all of that work, but some of it was work that was done developing the DOYLE engineering website. And so I suppose it's possible that the jury could have said to itself, we find that the work that Mr. KASSERIS performed on the website wasn't part of his ordinary job responsibilities with the company, so he wouldn't be entitled to wages for that time. But it also wasn't a volunteer project for which he expected no compensation. He was acting in reliance on Mr. Doyle's repeated representations that he would be paid his normal hourly wage for all hours worked, even if that work was not billable to a specific client or wasn't strictly within the ambit of his ordinary job responsibilities. So I suppose the jury might have decided, Mr. KASSERIS had job responsibilities at DOYLE Engineering, and he entered his time accurately when carrying out those responsibilities, and he was paid in full for carrying out those responsibilities. But over and above that, he also had this project where he worked on marketing initiatives, maintaining client lists, developing the website, stuff that might have been outside of his normal job duties. He didn't expect to do that for free.
Mr. Tinsley, just gets back to the fundamental inconsistency, at least in my mind, between the verdict form and the $44,000 award. Are you suggesting that those kinds of efforts of working on the website and so forth amounted to $44,000?
Yes, Your Honor. There was significant evidence on the record that the amount of time that my client spent on work for the DOYLE Engineering Company that he was not compensated for was very substantial, Your Honor. So yeah, absolutely. I think there's more than sufficient evidence in the record
Tinsley,
to support that.
as you're responding to these questions, I keep rolling back in my mind to your answer to or your response to a previous exchange that you had with Judge Englander. To me, this sounds less like negligent misrepresentation, less like even promissory estoppel, and an awful lot like quantum merit as a contract theory.
Yeah, I think the facts here, the evidence would have been sufficient to support a quantum merit claim.
But it wasn't
Yes.
given to the jury in that form.
Correct.
I mean, so one of the reasons I think that you hear these questions is because we're struggling to shoehorn this into a negligent misrepresentation context. We have to find what the representations are on which you relied, and then we have to ask the question whether those are actionable.
Yeah, put another way, it's not enough for you to say that there was evidence that was sufficient to support a jury verdict awarding damages under a theory that wasn't presented to them. You have to demonstrate how the evidence specifically tailors to the claim that was put to them.
Right. Well, sure, Your Honor. And I understand. I think I understand where you're coming from. I mean, I guess what I would say is, to begin with, I don't know that we have an issue here on appeal that's been properly preserved, because the way I understand my brother's argument, he's essentially saying that this is an inconsistent verdict, that you simply cannot square the verdict on the wage claim with the verdict on the negligent misrepresentation claim. But let's start there for a moment.
Well, he makes that argument, but he also makes an argument that Jamal, that his directed verdict should have been granted. That you did not satisfy each and every element. One of the arguments he makes is there was no actionable misrepresentation here, which you.
Yeah. Okay. Right. And I find that argument not particularly compelling, because the fact of the matter is, and we said from the outset, the standard on which we review the evidence here is extremely indulgent in favor of the plaintiff. So we're taking a look to see if there's any evidence whatsoever viewed in the light most favorable to Mr. KASSERIS that could support the claim. I think by that standard, this isn't even a particularly close call. Absolutely, there were representations that were actionable. And the representations do stem from this repeated promise that Mr. Doyle made that he would take care of Mr. Kasseris.
What does that mean?
Well,
What does that
I
mean?
fully understand when spoken in a vacuum without any of the appropriate context, it is difficult to understand that what it means. But that's not how these conversations took place. These conversations took place within a very specific context where, for example, Mr. Doyle would be instructing Mr. Kasseris not to enter certain hours into QuickBooks because he wouldn't be able to pay for those. And he'd tell Mr. Kasseris, we only have enough money to pay you for a few hours.
So that argument is that we should understand, I'll take care of you, to actually be the following, quote, I'll take care of you, parentheses, for that time, end parentheses. Unquote.
Correct. Yeah, and going forward, and as you continue to work more hours than you're paid for, I'll be taking care of you for those as well. Yes, that's right. So in that specific context, I'll take care of you is very specific, very clear, and Mr. Doyle knew exactly what he was leading Mr. Kasseris to infer. He was leading Mr. Kasseris to infer that persisting with this employment relationship and continuing to put time into projects for which he's not receiving compensation is not going to put Mr. Kasseris in a permanent financial hole, because eventually he's going to be made whole for all that time. He is going to be paid and compensated fairly for all that time. And that turned out not to be the case. And the jury concluded correctly in my eyes that Mr. Doyle knew or should have known, as he was engaging in that repeated pattern of behavior, that he wasn't going to make good on his promises and that Mr. Kasseris was not going to be made whole. And again, I think we demonstrated that in a variety of ways, one of which is by comparing Mr. Kasseris to a similarly situated project manager, the only other employee at the company, and look at how Mr. Doyle paid that person 32 hours a week, regular as clockwork, every single week. You don't see any week where she was paid for less than that. It was always the same.
So then now it's okay.
So Mr.
So you
Doyle
make that
knew.
argument. You make that argument. My guy didn't get paid. She got paid.
Yes.
Look how she got paid.
Right.
And the jury finds against you on whether he failed to pay all the wages due.
Yes, and to the extent that if my brother were correct, that these were just a flatly inconsistent verdict, then I suggest in my papers, the only appropriate way to reconcile that would be to reverse the verdict on the wage claim and say that Mr. Kasseris did in fact, because as my brother points out, the Wage Act is strict liability. So one of these two has to go.
Rita, we've been worried about inconsistent verdicts in criminal cases for a long time, and the answer is you can't take one thing that they said and say that's what they really meant. They are irrational because they are inconsistent. Once they're inconsistent, you can't make sense of them one way or the other. There's Supreme Court cases that say that.
I accept that, Your Honor. And from my standpoint, that's one of the reasons I began a few moments ago by saying I'm not sure we have this issue properly preserved on appeal, because to the extent that my brother thinks this was an inconsistent verdict, I understand it to have been his obligation to raise an objection right after the jury verdict was read and before the jury left for the day, because to the extent that it's an inconsistent verdict, the judge has to have the ability to query the jury about their basis for reaching certain conclusions so that we can tease out
what
the
case
full
do you
basis.
rely on for that? Because that's important.
There's a case, Your Honor, bear with me. There is a case, let's see here.
There was no objection here, I take it.
I don't believe so, Your Honor. Now, in Mr. Sullivan's defense, just to be fair, we ended this trial very late in the day. In fact, we kept court personnel in the building after hours in order to finish this trial. So again, to be fair to my brother, by the time the verdict was read, everybody was looking forward to leaving the building. And I think we were perhaps even instructed to be leaving immediately afterwards. But be that as it may, I think, yes, while the jury was still there, it was his obligation to make this objection heard so that the jury
Well, I
could be
just read
questioned
Rule
about it.
49, and I have to confess, I'm not that familiar with it.
Yeah, it's Rule 49B, I believe, Your Honor.
Yeah, when answers are inconsistent with each other and one or more is likewise inconsistent with the general, it's odd that it only comes up in B. Judgment shall not be entered, but the court shall return the jury. There's nothing there that says that an objection is required. So it would have to be in the case law, at least the way
Well, I see, here's a case for Your Honor. It's Babcock versus General Motors Corporation. 299 F3D 60, and that's a First Circuit decision from 2002.
says that there has to be an objection to the inconsistency.
Yeah. Yeah, there's a
Well, and the purpose of it is, as you described, to return the supposed inconsistency to the jury for them to continue further deliberations.
yes, Your Honor. Here's I can read a quote from another case. This is Trull versus Volkswagen of America. It's another 2002 First Circuit case, and they say we've held that under Rule 49B, objections to the inconsistency of verdicts must be made after the verdict is read and before the jury is discharged.
Right.
By failing to timely object to the jury instructions, VW thereby waived an objection it may have
You
had.
don't have a mass case that says that.
It's a First Circuit case, federal. I'll give you a mass state case, Your Honor. Stone versus W.E. Aubuchon Company. And the citation is 29 Mass Appellate Court 523. And that's a case from 1990. So that's a Massachusetts state case, Your Honor, from 1990.
Well, thank you. That's been helpful. That concludes the argument.
All right, and we are going live. And on the record.
Our next case is case number 2019 P1808, sex offender registry number 125770 versus the Sex Offender Registry Board. I will again remind counsel here on the record that the case is impounded, but this is a public hearing, so please refrain from reference to any of the names. With that, Mr. Erickson, you may begin.
If it pleases the court, Your Honor, my name is David Erickson. I represent SOR 125770, which comes on for appeal to this court after a decision in the Essex Superior Court. This is the appeal of a decision from December of 2017 of the Sex Offender Registry Board. I'd like to place the case in context because I believe all of the arguments sort of dovetail to the facts of the case. This is a 57-year-old man who's now 56. He has no prior sexual offenses or post-sexual offenses. All of his offenses were relate to a stepdaughter who was a older teenager. They had had a relationship of over 2 years, or he had been in the family for over 2 years. He was given a fairly substantial Superior Court state prison sentence. He has been released to the community. He had, testimony was there was a substantial family support as well as community support. And so I would ask the court to look at those facts and put the case in the sort of matrix of SORB decisions. I understand that the board's regulations don't assign they're not an actuarial instrument. They're a guide to the hearing officer to decide the case. In this case, however, there was the testimony of an expert I called Eric Brown, who's a forensic psychologist, and he testified to the score that the SOR 125770 received on the static 99. The static 99 is a...
One of the things, counsel, that concerned the hearing examiner about your expert was that he raised the fact, or he adverted to the fact that your client had been 3 years after he'd been charged, he'd been out on a pretrial release. And that during those 3 years, he'd engaged in no further sex offenses, including with the victim. And the hearing examiner was concerned that that evidenced the lack of careful attention to the record, because at the time he was under a order not to have any contact with the victim. What do you say to that?
I'm not sure I understand your question, Your Honor.
Well, one of the reasons that the hearing examiner was prepared to reject your expert's opinion was that he fixed on the fact that your expert cited this 3 years without any further sex offenses as a reason. And he said, but your client was under orders not to have any contact with the victim during those 3 years. Was he wrong? I mean, that seemed to me to be an appropriate reason to question the expert's opinions.
That it's based on that fundamental fact.
Well, it's one reason why you could look at what the expert says and say, geez, it doesn't look to me like he was very careful in the way he approached this particular opinion.
Meaning that he should not have considered the fact that
that it appeared to be a basis on which he was placing reliance, and it was wrong. Isn't that what he said?
I think an expert is allowed to consider all the facts and circumstances that they believe are relevant to a consideration of the case.
The manner in which they consider those facts and circumstances may, in the eyes of the hearing examiner, cause the hearing examiner to question the reliability of the expert's ultimate opinion, right? If they're placing inappropriate weight on a period of non-offense when they couldn't have offended, that would allow the hearing examiner to call into question how much value to place on the ultimate opinion. I think that's Judge Englander's point.
I think an expert is clearly allowed to look at all of the facts and circumstances of a case, to decide the case. And I don't think the opinion, I suppose an opinion could rely on a single fact, but I don't think in this case that it rises to that level.
Well, I don't think so either. I think he had the static 99, right? He'd done an analysis under static 99 and came out with very low risk. But I thought you might have a response to this particular concern, that's all.
Well,
I have a different question, and I don't mean to cut you off if you do have a response that you haven't yet given us. My question is just to remind us of the standard of our review, the standard review that we apply to the hearing examiner's decision.
The standard review, I've set it out in the brief. In essence, you give some deference to the fact that this is an agency decision, but I don't think that you absent yourself from a decision to look at the record and determine whether or not the decision was inappropriate. I can't quote the language.
This is an administrative decision, a decision by a hearing officer. We give deference to the expertise of the agency, right?
Clearly.
And we consider whether the decision is supported by substantial evidence, right?
clearly, but I think there's still some obligation on your part, Your Honor, to look to see if the decision is reasonable given
Well,
the
of
substantial
course, we
evidence.
have an obligation to review, or we wouldn't have, there would be no right to appeal. But as we conduct that review, we are not conducting it de novo. We don't substitute our judgment for the judgment of the hearing examiner, and we recognize that that the application of these various factors is not done in, as you've acknowledged, in a rigid or mathematical form, right?
Clearly, and that's why I began my argument with trying to put the case in a, in a matrix. I would suggest to the court that this is an unusual case in that this is an incest offender who's now in his, mid-late 50s that does not have, anything that when you do a static on him, places him, his risk is 2% over 5 years. And I think I would suggest to the court on any of these cases can, pick and choose out particular facts that might.
Mr. Erickson, if I could interrupt, I grant you that on the basis of your expert's testimony, perhaps you had more to work with, or the petitioner had more to work with in this case than some others. But do you agree that the hearing examiner was not bound to accept the expert's testimony to the extent that it conflicted at all with the agency's own regulations?
I don't think that the expert, has to apply the expert doesn't have to get up and say, these are the regulations and I applied them and this is the conclusion I come to. The expert, and I believe that's the holding of this court, the expert has to, look at the case and make a determination about the facts and circumstances, and based upon his education, training, experience, come to a conclusion, somewhat like the hearing officer is supposed to do, I suppose, or it's at least analogous. In this case, my view is obviously that when one looks at the decision of the or the opinion of the expert and the decision of the board, they're so at variance that it's, causes one to stop and look at it. In part, that's why the age argument I made, that if one looks at this is a very, very well-known Hansen graph about risk of recidivism among the 3 classes of offenders. SOR 125770 is an incest offender. His risk in his 50s is, diminishing, again into the single digits. If he's an extra familial child molester, his risk is, substantially more and stays higher, into his 70s. An incest offender trails off. It's the same on the question of whether or not this offense is committed in the public. It's committed in a in a rural Massachusetts community, on kind of a back road at a filling station.
You're talking about the public place. I mean, that's certainly not the only offense. He committed offenses in the home. He committed offenses in Louisiana. He committed offenses everywhere for 18 months, according to the testimony.
However, Your Honor, the Commonwealth confesses to error on this point, that he
on public place, yeah,
public place, the hearing officer, got it wrong and applied weight to that factor. And again, this is a level 3 case. This is internet dissemination. This affirmative, disclosure in the community. respectfully, Your Honor, if you say there's substantial evidence, I'd say it's thin at best, and so that any error on the hearing officer's part is fatal to the decision, and it should be remanded. The denial point is, I don't think there's anything in the board's regulations that talk about, the opinions of, family members, friends, colleagues, if they think somebody did or didn't do something.
But I mean, he uses it in a very particular way, which to me makes sense. He says, because they believe that he did not do it, they are less likely to provide support with respect to sexual offenses than repeats of sexual offenses. I mean, the evaluations for whether he's going to repeat what he's done in the past. The mitigating factors having to do with support go to who's around him and will they have an impact on whether or not he repeats. And all I think that the examiner is saying is where they don't believe he did it in the first place, they're not going to be able to provide support, at least in that
way. It's clearly not in the regulations, and to the extent denial is, has been considered, it's long accepted that denial is not relevant to risk. And Your Honor, I would suggest that
not relevant to risk, but that's his denial.
Well, risk, I think risk is risk, and
No, but to Judge Englander's Judge Englander's question, I think, goes to the question whether to the extent that support is important, we're looking to whether the family members are likely to help regulate his activities, or conversely, might tend to enable his offending activities. And it seems to me that denial does enter into that equation in a way that it doesn't. And there's also due process and self-incrimination concerns on the petitioner's denial that don't apply to the others.
These decisions are supposed to be evidence driven, and I don't think that there's research to support that. And respectfully, Your Honor, if an individual is under an order of the Superior Court and his family is supportive of him, I'd suggest that the exact opposite is true, that they're going to do anything and everything they can to assist him. This is a man that received a substantial sentence. I think they're clear on what they should do. Thank you very much. I rely on my brief.
Thank you. Attorney Bonsi. You have to unmute yourself, sir. Yeah, there we go. May begin. Kristen, you can start the clock.
Chief Justice Green, Justice Kinder, Justice Englander, good afternoon. May it please the court, John Bosse for the Sex Offender Registry Board. The SORB respectfully requests that this court affirm the hearing examiner's decision to classify Doe as a level 3 sex offender. Regarding the rejection of Dr. Brown's expert opinion, the SORB submits that it was proper for the hearing examiner to reject the expert opinion. Dr. Brown placed emphasis on 3 inapplicable factors, such as the fact that the victim was intrafamilial, that the offender had 3 years of offense-free time while he was awaiting the charges on the governing sex offenses, and that he had the absence of an alcohol and drug abuse history.
How did you characterize those? I'm sorry, did you just said he relied on inapplicable factors?
Dr. Brown placed significant reliance on 3 inapplicable factors.
Why are they inapplicable? He's an expert in this field. He identifies 3 reasons why this particular defendant is less likely to recidivate. Why can't he do that? And don't all of those reasons, at least I've seen enough of these cases now, I know you've seen a lot more, those seem to me, when there is evidence of alcohol, when there is evidence of multiple victims, when there is evidence of victims outside the family, then you guys come in here and say, look at this. This is why they're a level 3. None of those things are present here.
Correct. And because they're considered risk elevating if there's evidence of that the victim was extrafamiliar or a stranger, if there's evidence that the offender is abusing alcohol or drugs, or risk mitigating if there's evidence of offense-free time in the community. But our argument is that they're inapplicable, and a Supreme Judicial Court from 2006 said inapplicable factors are not considered or weighed in the classification process.
And so if the expert relies on them, you reject the expert's opinion for that reason? That doesn't seem to me to follow. It's one thing to say the absence of factors is not something that is to be considered in evaluating the factors, and another thing to say the expert opinion is to be rejected for that reason.
Well, if the hearing examiner is not required to consider them, then we submit that it was not that it was not proper for the hearing examiner to consider them, but just that they don't support the expert's opinion that the offender poses a low risk to reoffend.
That there is a fundamental disconnect in my mind with the argument that you're making. It basically, and I think actually the argument is inconsistent with some of our case law. You seem to be saying the expert's opinion is not valid because he is not following the regs exactly as the regs are written. And I thought we had case law that said that's wrong.
Well, I believe you. I should say, I think you make a good point, Justice Englander. But I believe it certainly served as a basis for the examiner to reject the expert's opinion.
Perhaps.
Yeah.
Let me ask you a couple of other questions because they are big ticket items, it seems to me, in terms of the overall posture of this appeal. And they are, first of all, there is no, this case predated the SJC cases that required an explicit finding on internet dissemination. It was prospective rather. We need not do it if we are satisfied that internet dissemination is not required. So you're going to address that for us, I'm sure. Separately, you have conceded that factor 16 was improperly applied, the public place question. And again, you're going to need to explain to us why that isn't cause to question the hearing examiner's ultimate conclusion in a level 3 case involving a single victim.
Yes, Your Honor. I'll first address the issue about internet publication. SORB submits that it's not necessary that this case be remanded to the hearing examiner to make an explicit finding of internet publication because of Doe's sexual misconduct between 2000 and 2002 against a victim who was between 13 and 15 at the time. There's a high level of penetration. Additionally, Doe was offered the opportunity to participate in sex offender treatment, and he refused the treatment. Of course, he refused it because he states that he did not commit the sex offenses. And I also think that another reason why it's not necessary to remand for internet publication is something that the Supreme Judicial Court said in 2019. We do cite to it in our brief 496-501 they said that the hearing examiner can, with regard to the degree of dangerousness, the hearing examiner can consider the fact that the sex offender, if the offender has been incarcerated for quite some number of years, did not have the opportunity to commit sex offenses in prison. And so in this case, the offender at the time of his classification hearing was in prison for 12 years and did not have the opportunity to commit sex offenses against young, vulnerable girls. And we believe that based upon all of the evidence before the hearing examiner, internet publication is necessary to protect young women in the community. With regard to Factor 16, the public place, I did look, Factor 16 is supported by one scientific study, and I did read that study, and Attorney Erickson is correct that that study states that a sex offense occurring in a car is not considered a public place. However, as Justice Englander noted earlier, there was sexual offending that occurred in addition to the sex offense that occurred in Doe's truck. And it's our position that the offender was not prejudiced by the application of Factor 16 because the hearing examiner applied a number of other factors, including two high-risk factors: repetitive and compulsive behavior, and a sex offender committing a sex offense against a child. In addition to the fact that the offender refused sex offender treatment in prison, and his mother and two sisters do not believe that the offender committed the governing sex offenses.
Yeah, well, but that last thing that you identified is not a basis for any kind of risk assessment, right?
With regard to the support,
it just has to do with mitigation and how much mitigation you're going to apply. But it's not an affirmative basis, right?
That's correct, Justice Englander.
Level 3 is pretty high for this, isn't it?
Mr. Doe, he's only 53 years old. And so Factor 30 states that advanced age shall be given full mitigating weight when an offender has reached 60 and they committed a sex offense.
I understand. I'm quite serious about the question. This, given the array of cases I've seen, seems to be an unusual level 3. He has one victim. It's 20 years ago. He was present. He has no other victims. He was 40 years old at the time he went to jail, right? Roughly. And very little evidence of violent behavior on his part. Although, there are other things that I do see in the record that indicate that he, he employed at least psychological pressures in order to have these rapes occur. I don't know.
In Justice Englander, you make a great point. Sometimes it is a difficult call between a level 3 and level 2. And I would just say that the best case, I think, to compare this to is an SJC case from 2019 that I cite at my brief. And in that case, they affirmed a level 2 classification where the offender was 65 years old at the time of the classification hearing and had 4 years of offense-free time in the community and had established stability in the community during those 4 years. But nevertheless, in that case, that individual was a repeat sex offender multiple times. His last sex offense was in 1997. Here, the last sex offense was in 2002. And compared to the SJC case, the offender in this case is 53. The offender in the SJC case that I talk about was.
But was that other offender at level 3 or a level 2?
They said a level 2 was appropriate in that case. And I do cite to that case in my brief a number of times. I believe I talk about the specifics of that case at page 36 and 39.
Thank you, Counsel.
Sure. Does the court have any further questions? I believe I've made all my points, and unless the court has any further question, I would respectfully rest on my brief.
Okay, and we are live and on the record.
The final case on our list for hearing this morning is a case involving the termination of parental rights. It's case number 2020 P630. The case is impounded. I have admonished counsel to avoid reference to any of the names of the parties involved, parties or other participants involved in the case, and refer to them by their status in the case: mother, father, child, etc. With that preface, Attorney Krasner, you may begin.
Thank you. May it please the court, I'm Sherry Krasner on behalf of Mother, who's watching this broadcast on live stream. I'm splitting my time evenly with Father's Counsel. The third appellant in this case, the oldest child, has informed the panel with a letter that he is present but not arguing because that child is now back with Mother. As I argue in my brief, the judge committed harmful error in concluding that DCF used reasonable efforts in working with this family. He drew unreasonable inferences about Mother's expert, and he ignored all of the recommendations in the investigator's report. But because my time here today is short, I'd like to focus on the serious error that the judge committed in concluding that my client and her husband were unfit because of the purported poor judgment they exercised with respect to their housing choices.
Ms. Krasner, briefly before you leave reasonable efforts, could you respond to the department and the children's claim that that is an issue that was not preserved?
What I would say, Your Honor, I would refer them to adoption of West, the recent appellate case, about a year old, that talks about if an issue is generally known, if there's a theme that runs through the case, and certainly the issue with respect to cleanliness of the home was an issue that was before the court in a variety of circumstances. So I would suggest that based on West and the fact that it was a theme in the case, that it was in fact a preserved issue.
Thank you.
But certainly, but going back to the issue of the housing choices, the critical conclusion of law here is conclusion number 7, and the unsustainable findings on which it rests are findings 137 to 140 and findings 207 and 208. I want to remind the panel that according to the ongoing worker, the mother here had complied with all of her action plan tasks at the time of trial. That's detailed in my brief and in the record at transcript pages 953 to 1002. But in thinking about the error here about housing, I want to remind the courts, I think you certainly understand that the purpose of care and protection litigation is to protect children and not to punish parents. Yet in this case, over and over again, the trial judge excoriates the parents for the mess that they seem to have gotten themselves into, and intimating that it is for that reason that they are not fit and that the children shouldn't be returned. There's so much wrong with that finding and that intimation. First of all, the parents did have a place to live at the time of trial. They were living with the maternal grandmother.
Although, as I recall from the record, that was an apartment that already had 2 people in it. So the proposal would have been to add the couple and 4 children under 5 plus the teenager, correct?
That is correct. And that may not be the way that we all would want to live, but that's certainly not a reason for finding unfitness. And it's certainly the almost similar fact pattern in adoption of Leland. This court found that it wasn't sufficient to terminate rights based on the fact that it was an overcrowded home. So there was a home, there was a place in which the parents could live, in which the children could live. Also, the parents
As
had
I
made,
read the findings, though, counsel, I didn't read the findings to be driven by the issue of their current ability or inability to live in a 2-bedroom or two-room home with their mother. I read them to be driven by years and years of inability to keep their house in a way that wasn't going to be harmful or neglectful to the children. And are you asking us to find that finding, and there is an explicit finding that he doesn't see that situation to be righted in the indefinite future, that finding was clear error on this record?
I say it was, Your Honor. And I say because the issue before the court was current fitness. What were the current circumstances? And in the time after the removal in September of 2018 until trial commenced in October of 2019, the social worker made regular visits to the home, to the grandmother's home once they moved into the grandmother's home in March of 2019. The most recent visit was in August of 2019 before she gave her testimony in October of 2019. And at that time, there were no issues with the cleanliness of the home. So in terms of what the situation was at the time of trial, the parents had ameliorated that.
Well, that can't possibly be. It can't possibly be because they cleaned up the day before trial, that problems that extended over a period of 7 years evaporate. I mean, right?
And it was just simply the day before trial. There were periodic visits during those months, and there were no problems with the cleanliness of the home. And I would also say, Your Honor, even acknowledging that there were times when the home was not in appropriate condition, it wasn't a constant condition. This was a family that sadly was plagued with serious medical problems, a husband who had a stroke when he was in his 30s, a child who's not the subject of this petition, who had multiple behavioral issues. And it were at some times when the family reached a boiling point, that there were times that housekeeping took a back seat to dealing with those medical problems, with the behavioral problems of the children. It was not, in fact, there were many, many times. The first ongoing worker in this home, I believe she made 17 visits to the home and talked about cleanliness being an issue only on a few discrete issues. So I would say, looking at the evidence in that framework and the most current evidence, which is the evidence that the trial judge was obliged to look at, that the issue of cleanliness was not a problem upon which a finding of unfitness and the severe consequence of termination.
In fairness, though, it's to describe the cleanliness as housekeeping taking a backseat to other priorities understates the extent of the judge's findings. Right? This was a very advanced state of feces caked on to surfaces. So this is not just sort of not running the vacuum cleaner twice a day. This is, or dishes stacked up, food left out, urine, pervasive animals that are out of control. I mean, this was a rather serious. Well,
I see even if we accept that as true, Your Honor, that was in September of 2018, and this matter went to trial at the end of 2019 and the beginning of 2020, and those were not the circumstances of the home in which the family was living.
Thank you. We'll hear from Attorney Camo for the father.
Thank you very much, Your Honor. May it please the court. I'm William Como, and I represent the appellant father. Briefly, first, I'd just like to address two things that my sister spoke about or was asked about. At the time of trial, although initially there were two people living in the grandmother's home, the grandmother, and she had a boarder in the other bedroom, that person had moved out. So by the time that the trial occurred, there were only family members in that home. Secondly, I have scanned this record, and I hope I'm not going to be corrected, but my belief is that from September 30th, 2018, up until the trial, which occurred throughout September into 2019, and I believe may have ended at the end of 2019, this house was clean. Before I go into that, though, I really want to I guess, focus on a couple of things that the court said and that my sister for the department mentioned in her brief that are incorrect. And I think that may take off this cloud of whether the house was clean or not. In finding number 164, it states, of significance, mother admitted at trial that she was still having problems maintaining the home, even though none of the children are with her and she is living just with two other adults, her mother and her husband. She maintained that she was not working nonstop on the cleaning issue. Now, likewise, the department states on page 42 of its brief, mother testified in September of 2019 that she was still struggling to maintain the home despite no children living with them. That's based on, she cites finding 164 and also refers to the transcript on page 102. On page 101 and 102 of the transcript, and that is from the hearing on September 18th, 2019. In it, she was asked, the mother was asked, prior to the September 30th, 2018 removal of the children because of the dirty house, you had been doing therapy. Answer, yes. And despite the years of therapy you've been doing, you still, up to September 30th, 2019, are having issues with the condition of your home. Is that correct? Yes. The problem is that September 30th, 2019 was still 12 days away. It's clear that the mother, in the context of this conversation discussing September 30th, 2018, was answering about September 30th, 2018. She wasn't saying that currently the house was the house had been filthy or she had any issues with it. The social worker testified very clearly that the house was always clean whenever she was there. That was from October of 2018 all the way through March of 2018, excuse me, 19. And in March of 2019, the parents moved to the grandmother's home. The DCF attorney and the court again claimed that the mother would not permit them to see the home. And if I could just find my spot, the page 946 of the transcript, the social worker testified after being asked, why don't you do a home visit at the maternal grandmother's house? Because mother told me that her mother did not want DCF at her house because all the drama we have caused. So it wasn't the mother not permitting DCF into the home, it was the grandmother. But when they were permitted back into the home by the grandmother in August, September, and October of 2019, again, that apartment was clean. There's nothing else in this record to suggest that the apartment was unclean. The only other factor that the department cites.
Help me with this. The
Yes.
grandmother's, is it a two-room apartment?
It's a two-bedroom apartment, Your Honor, yes.
Two-bedroom apartment.
Yes.
Into which there would be 3 adults and 4 children? That's what's proposed?
Well, you know, honestly, Judge,
Or 5?
Certainly the parents want all the children back, but it's not, you know, you take one or you don't take them all, or you take them all. I mean, They could have
Well,
sent one
what was
child
the
back. They
evidence?
could have sent two
What's
back.
being proposed? You say that you want to see the order overturned. What
Yes.
is what was, actually, I suppose the question is, what was proposed at trial?
The proposal at trial was that they were looking for housing, and in the meantime, they were going to be staying with the grandma. That
So
was their
3 adults and 5 children.
with 3 adults and 5 children. Yes, Your Honor. Yes, and there's plenty of case law that suggests that just because you don't have adequate housing, that's not an appropriate means or a reason to terminate parental rights. I don't have the cites off the top of my head, but I'm happy to send
No,
them.
I can accept that, but when you have a long history of being unable to keep your house clean to the point where the word squalor is repeatedly used,
Right.
I think you have a somewhat different set of facts.
And that's absolutely true, Your Honor, except unless there are some intervening factors that suggest to the court that that is no longer going to be the case. If I could get
And
to
the
that.
intervening factor here is what?
Well, there's several. The father, first of all, participated in all services. He participated in therapy, where he learned that he was not doing what he was supposed to be doing as a parent. He understood that he had been lazy. He testified to this during the trial, that he understood that he had gained insight basically into what it was that he had been doing wrong. He had been letting the mother, who had her own health issues, do all the work. He changed. He became a partner to the mother, as opposed to simply letting her do the work and take care of him and the 4 or 5 kids. So that changed. He got into an anger management class, and he learned that his anger erupted from his failure. This is from his testimony in the past, to accept his responsibility as a parent. He's supporting his wife, doing his part in the home, and placing his family first. In counseling, he worked on techniques to complete household chores. He got his mental health under control, Judge. He suffers from, among other things, ADHD and depression. Depression can be extremely debilitating, but if you have it under control, it also gives you an opportunity to do the things that you maybe knew you should have been doing, but weren't doing. Now he's doing them. He's gotten his depression under control. He's gotten his ADHD under control. That's important. That's through medication and meditation. That's important because now he's able to concentrate, and as a result is able to assist his partner in caring for his home. His anxiety has resolved, and he doesn't. And his depression is, although he still has it, is not as frequent as a result of what he learned in his therapy. He participated in parenting classes, and in the parenting classes, as a result of those, he said he learned that when you're a parent, this is a quote, "When you're a parent, it's not about you anymore. You need to do whatever it takes to keep your child safe." There's no history that his father was doing that. I apologize, Your Honor.
Yes, I think we'll have to leave it there. We will take your brief for the remaining points.
Thank you very much.
Ms. Brodigan?
Thank you. Good afternoon, Your Honors. Again, my name is Gretchen Brodigan, and I represent the Department of Children and Families in this matter. And the department respectfully requests that this court affirm the finding of the trial court. Your Honors, I would like to first address a couple of the points made by both Attorney Krasner and Attorney Kamal relative to the mother and father's argument in this case. First of all, Your Honors, with respect to mother's argument regarding the housing situation, I would suggest that, as I think the court has already pointed out, in no way was the sole and exclusive reason for the court's finding of unfitness in this case. And certainly the Commonwealth, or excuse me, the department does not disagree with the fact, the standard under Linus, that children should never be removed from parents and placed into substitute care on the sole basis of homelessness. But certainly, Your Honors, in this case, there were multiple factors that the court considered in making a determination that the housing in this situation was unfit. As I stated in my brief, Your Honors, we saw that back in September of 2018, when the parents were aware that the landlord and realtors were coming to visit the house, they made no efforts to ameliorate the horrendous squalid conditions, which are detailed by the testimony of the emergency response worker, in which I quoted word for word in my brief because they were so horrifying and deplorable at that time.
Ms. Brodigan, how do you respond to the mother's suggestion that that was a prior infirmity that has been remedied and has remained remedied for the past year and a half?
Well, first of all, Your Honor, I would suggest that, and I think this addresses both parents' argument, that whether or not it was the maternal grandmother or the parents who prevented DCF from visiting the maternal grandmother's home between April of 2019 and September of 2019, the fact is that DCF didn't visit that home. So to suggest that the court can and should draw a conclusion that this issue of squalor was ameliorated during that time, I don't think there's sufficient evidence, and certainly the record doesn't show that there's sufficient evidence to base that on, because DCF—
Is it accurate that between September of 2018 and March of 2019, there were a number of visits to the parents' home and the home was clean?
I believe that's correct, Your Honor. Yes, I think that the record supports that, although I would note, as I said in my brief, that when a worker visited the home in February of 2019, noting that the home was largely packed up as the parents were getting ready to leave, that there was still the odor of urine in the house, suggesting that, again, there were still issues in the home, even though at that point in time, Your Honors, that the parents were the only two individuals in the home. None of the children were in the home at that period of time. And I would suggest that, the parents were fully aware that the circumstances of this squalor could lead them to lose their children. This could lead them to lose their housing. And in fact, as the court already pointed out, the fact that both parents elected, after months of supposedly looking for housing and ultimately, not finding housing and losing the Section 8 voucher, which would have allowed them to afford and have suitable housing for their children, they elected to move in with the maternal grandmother, which, as the court has already pointed out, this is an individual who lived in a 2-bedroom home, to which the family was suggesting it would be appropriate or conceivable to realistically move back 4 children. And again, at the time of the trial, then there was also a baby in the home as well. So that would have been 5 children living with the 2 parents along with the maternal grandmother in a 2-bedroom home where they were not on the lease. She was living there under a Section 8 voucher, which the parents were not on or allowed to be on. And certainly those were situations which could have resulted in eviction from the family, including the maternal grandmother, from that housing. But again, Your Honors, I would suggest that the issue of the housing and the conclusions that the judge made, that was one of many conclusions that the judge made in finding unfitness. But the overwhelming evidence that the judge relied upon, the clear and convincing evidence, was, as the court has pointed out, the years of unameliorated and unmitigated squalor that existed in this home. And again, to suggest that this was an issue of housekeeping, that it was an issue that only happened, a few times over the course of these years, is simply not supported by the evidence in the record. We have seen that in 2013, the police responded to a violent incident by mother where she exposed her oldest child to violence. At that point in time, there are squalid, deplorable conditions in the home, to the point that the oldest child, had to be sent to stay with a friend so that the mother could address the concerns in the home. Your Honors, over the course of time, there were numerous occasions where DCF went in and observed deplorable conditions. There were situations where they failed housing inspections because the amount of trash that was found in the yard. There were health.
The observations that you quoted in your brief,
yes, Your Honor,
were from September of 2018 when the police entered by breaking down the door?
That's correct, Your Honor, yes.
And trial was December of 2019?
The trial, Your Honor, it was on 8 non-consecutive days between September 5th of 2019 and December 9th of 2019. So approximately a year after that. But Judge—
And the children were removed right after the September of 2018 event?
Yes, Your Honor, that's correct.
And at the time that they went in to the home in September of 2018, the people living in the home were mother, father, 5 children, correct?
Your Honor, at that time, the oldest child, the autistic child who is just mother's child, was not in the home.
So 4 children, 4 children under the age of 5.
Yes, Your Honor, I believe that is correct.
Right.
Judge, I would also note, and I think it's extremely important for the court to take into consideration, that the trial court properly relied on prior patterns of ongoing, repeated, serious parental neglect in determining current unfitness, and that a pattern of past behavior has prognostic value. The case law is very clear on that. And to suggest that the DCF conceded that the parents participated in services that were offered at various points in time, although their participation rather was not consistent and sometimes not at all. But particularly, I think important is the fact that the court has to find that there was meaningful insight gained by the parents or changes in the behavior that was made based upon the participation in those services. And that was not the case here, Your Honors. In addition, which I don't think has been mentioned yet, which I highlight in my brief as well, the court clearly based the finding of unfitness not just on the squalor, but upon the repeated exposure of the children, one or more of the children, to violence in the home. And Your Honors, you are aware through the evidence in this case that the police responded to the home as early as February of 2013 for an assault between the mother and a neighbor, which occurred in the mother's home, and the eldest child was home and witnessed that event at that time. The police also responded, as you know, in September of 2017 for an incident in which which the oldest child, the autistic child, intervened in a verbal argument that was going on between the two parents to try and help his mother. And it resulted in the father pinning that child to the ground and punching him repeatedly in the face. And at that point in time, the two younger daughters were also home and witness to that event. And on the most recent event leading to the removal of the children on September 30th of 2018, the court has heard that when DCF went accompanied by Taunton Police Department to that home in order to respond to the emergency 51A that was filed by the realtor and landlord based upon their horror at the squalid conditions, both parents yelled at and screamed at police and DCF, prevented them from coming in, ostensibly not to see the state of the home, resulting in the police having to break the door down to get inside to assure the safety of the children. And subsequent to that, mother attacked and assaulted a police officer, again, where the three younger children were home and witness to this, and resulting in her arrest and removal from the home. So, Your Honors, with respect to the evidence in this case, I would suggest that it is eminently clear that the trial judge made his findings of unfitness based upon not just failure to keep house, failure to be clean at certain times, but persistent conditions, unaddressed and unmitigated, of squalor in this home, which led to extreme safety and health concerns for these children, as well as repeated exposure to incidences of violence. And I would just state, Your Honors, that I think the record is also quite clear based on the evidence that DCF made reasonable efforts over the course of well over 5 years to provide targeted, appropriate services to this family. And in spite of that, their behavior went unchanged. And for those reasons, I'm asking that the court affirm the findings of the trial court.
Thank you. Attorney Anderson.
May it please the court. My name is Scott Anderson. I represent the children in this case. I would like to ask you to think of the consequences of a decision here. If this verdict were to stand, then we would have the parents with their oldest son and their youngest child. If we look at the record, mother did okay with her oldest son for quite a while. That's one of the wrinkles in this case, where there were stretches of time when she had one child, things seemed to not going great all the time, but went okay. But when you add the children, when you add the father's daughter, when you add the other children into the mix, and you have 2, 3, 4 children, things break down. And that's what the record tells us. So right now, what we have is a situation, if we let the verdict stand, we have the parents with 2 children, and we have 3 siblings who have been raised together.
You say the parents with 2 children. Are you telling me that since the decision of the judge, the youngest child has been returned to the parents?
Oh, I'm sorry, Your Honor. I'm not sure about, I don't have any record of that. I
It
thought
was
that
temporarily removed as of the time that I think that the brief came in.
okay, I apologize. I thought the oldest son was returned. The youngest child may not have been. I spoke out of turn. I apologize. But in any event, with the oldest son, it seemed somewhat manageable. But when you threw in the father's daughter and the additional children as they were being born, things broke down. So I will go through a few of the claims of the briefs. Well, the first thing I was going to say is the mother's attorney, my sister, spoke of Leland and tried to equate Leland with this case. The facts could not be more different. In that case, you had 6 or 7 family members in a 3-bedroom home. As you, Your Honor, pointed out yourself, we would have 7 people crammed into a bedroom. And there's a certain, I mean, I don't know if there's a bright line, probably not, but there is certainly, we go from what's undesirable into what's irrational. And if you have a teenager with special needs and you have an infant, and then you have 3 in between, and then you have the 2 parents here, it crosses some kind of line somewhere. I can't draw it, but I see it. Beyond that, I listened to the arguments of my brother counsel for father, and I'm just not sure what else I need to rebut. I would add, there was this claim about court investigative recommendations, which confused me in mother's brief. There's no support in law or case law to the idea that a judge's ability to weigh facts and determine whether DCF's efforts were sufficient should be narrowed by the opinion of a court investigator's opinion. When in the same argument, rightly so, mother's attorney argues the purpose of the investigator is to steer as wide a course as possible, like to add to the judge's options, not narrow the judge's options as far as the material being considered and what the judge might consider and how. Then she turns to argue now the judge is almost subservient to the investigator's recommendation. I really don't understand that. So I point that out to the panel. I think I'd let my arguments rest with my brief, unless there's any questions.
Seeing none, we will leave it there. Thank you all. The case is